2021. Thank you, Judge.
Thank you. Where are our evidence leaders, Mr. Late?
As the court pleases, my lady, I'm here.
There is a hand here by Mr. van Bergen.
Thank you, my lady. My apologies to both you and Mr. Late. If I may just raise an issue pertaining to the order in which argument will be presented, my lady.
Yes.
When this was discussed, in order to assist your ladyship with an agreed program, so to speak, and I must thank Ms. Hassam and her team for the initiative in doing this, I indicated that I would need to reply to allegations contained in the heads of argument on behalf of Mr. Profi's clients,
Yes.
and that I would have to come in line after him. I note that I am not in that position, and I would just request that my argument be held in abeyance until Mr. Profi has argued, as your ladyship pleases.
Is it, or you don't want to continue with your argument and then after he had argued, then you respond? You
No, my
reply.
lady, I
You
think
just
that
want to do it once.
I want to do it in one session, my lady. I don't think it's necessary to.
Okay, you
first
can just
argue and
remind
then
me. I
go
don't
back.
think there is any. Is there any problem? I don't think there is any problem with that. Any party that is against this?
May it please the court, my lady, no objection.
Mr.
No objection, my lady.
Mr. Profi, where are you? Yes, I see Mr. Rikgotso. Who's Rikgotso here? We have never had any Rikgotso. There is a hand. Can I hear you?
As it pleases the court, my lady, my apologies. Indeed, you've never had Mr. Kotso before you. I am appearing for the premier with Mr. Mukari SC. He's not with us at the moment. He will join us
Are
a
you
little bit
standing
later.
in for him, or
And
what is happening? Have you been with him?
For
all
the
along?
moment,
Yes, you want to say something?
I'm with him. Not in relation to the previous submission of my learned colleague wanting to submit to do his heads after somebody else. It's just it had nothing to do with that. Mine was just in relation to the heads of the premier as well as Ms. Creasy. We asked that we be put at the end because we don't have much to say in relation to that. So I wasn't sure in terms of which order we have been placed in, my lady. That's why it's
fine.
just a hand.
Whoever is not in the agreement, I'll just go through the list, the way we have been proceeding. Then it will be according. Yes, we'll just see as to where we can fit you people. All right, Mr. Profi.
As the court pleases.
I'm just trying to get that proposal. Yes.
But my only comment is that I think it would only be procedurally correct, and as well as how the evidence has flowed, that how the facts go is from Life Esidimeni to the NGOs, that it would just, for the sake of flow, work better if Mr. Van Bergen goes before me, but I'm in the court's hands in how the court wants to direct it, because either one of us are going to reply, whether it's him or me, one of us are going to, we're going to reply anyway. So whether he goes first, I go and he replies,
okay, so
or
it's
he
fine.
goes, I goes, he replies, there's going to be a reply either way.
Okay.
Which is why I think we should stick to how it's been going.
Thank you. Mr. Late, are you ready to start?
As the court pleases, my lady, I'm really going to be very, very brief.
Yes.
And if I can proceed at this stage, thank you, my lady.
Yes, you may proceed. I just wanted to get that list.
Thank you, my lady. The identifier on the filing sheet of our arguments is actually a misnomer. We did not file heads of argument, but a written argument. We stand by our written arguments, after having read all the arguments of the other parties. To repeat those arguments orally will only serve no purpose other than burdening the record. Repeating a truth doesn't make it a greater truth, and in the same breath, repeating a lie doesn't make it a truth. Most of our concerns with the arguments of other parties have been addressed in other arguments, and we believe that a full picture of available arguments to assist the court in coming to correct findings is before court and will be before court after the oral arguments. Just allow me to quickly respond to some of Section 27's responses to our arguments. In paragraphs 5 to 7 to 531, that is on case lines 55068.
Come again?
Case lines 55068 to
55068.
55070.
Yes, paragraphs.
That is paragraph 5 to 7 to 531. The evidence leaders.
Can I quickly go there? I'm just there, just bear with me. Yes, Mr. Late.
Thank you, my lady. The evidence leaders.
On these pages, you refer to paragraphs 2, 5
to 7 to 531.
Okay. Yes, continue.
Our argument regarding the burden of proof is criticized there. And there is reference made to several cases in the heads of argument, and all deal with a lesser burden of proof. And that lesser burden of proof isn't named at all or in any way defined than the criminal burden of proof of beyond reasonable doubt. And all this is done by those cases with reference to an inquest court not having to make the same credibility and acceptability findings a trial court is supposed to make. I totally agree with that.
Yes.
Whatever this burden of proof entails and how it should practically be applied, by reading our discussions in context, it's clear that our submissions and suggestions were structured by applying the relevant legal principles to objectively discernible facts.
Yes.
Credibility and acceptability were not discussed by us. No matter what burden of proof is applied, the same conclusions will be reached when dealing only with objective facts.
Yes.
The reference to beyond a reasonable doubt was purely to indicate that should a criminal trial commence after these proceedings, that is what the state will have to prove in a criminal trial beyond a reasonable doubt. As regards
So
The
you are
arguments-
saying you agree that the standard that you have referred to is not the standard that is applicable in the inquest court.
when the court deals with credibility and acceptability issues. But if it's an objective fact that has to be adjudicated, it's common sense that it must apply when working towards a criminal trial.
Yeah, I hear you, but I'm not sure that I get what you want to say.
What I understand,
On the other hand, what I understand from what you are saying is that whether you are being criticized regarding the standard, the burden of proof, in any event, if one looks at the objective facts, the conclusions that you have made or the principles that you have applied in
Yes.
respect to those particular facts that we are facing,
yes,
one would reach the same conclusion. That's how I understand. Yes.
that's exactly what I say, my lady.
Okay.
Thank you.
Thank you. Any other thing?
I want now to refer to the arguments on behalf of the four families, as well as the arguments on behalf of Mrs. Jacobus. And I submit that it's not worth replying thereto. And we agree with the sentiments.
Are you saying even those of Mr. Pinar
Yes.
with regard to Ms. Hannah Jacobus?
Yes, that's correct, my
Okay.
lady.
What are you saying with regard to
We
that?
agree with the sentiments on behalf of Dr. Salabanu and Mr. Nogi, as voiced in their supplementary arguments as to the value thereof.
Lebano and Musenogi.
That's correct. Both of them filed supplementary arguments in which they reply to the heads of arguments of Mrs. Jacobus and the four families. At least they. Furthermore, my lady,
Just a second. Just a second. Yes, continue.
Furthermore, as regards the arguments on behalf of the four families, we are not going to dignify Mrs. Foster's extremely unprofessional, uncalled for, and untruthful remarks targeted at us in paragraph 7 and 8, that is on page 55340.
55340, paragraph 7 and 8.
55341.
Paragraph 7 to 8.
That's correct. Of the heads of argument, and with any argument or reply, other to say that these remarks are of no assistance to the duty of this court in terms of the Inquest Act. The manner in which the investigation was performed, the witnesses consulted and recorded, which recording formed the basis of most of the affidavits filed under the heading General Statements on case lines, was put on record and it was never disputed. Some of the witnesses even testified to the fact that we had consulted with them and their consultations were recorded. Others submit that after all the arguments...
Come again? Yes. I didn't pick that up. What are you saying with regard to... yes?
I said that it was put on record by ourselves, and even some of the witnesses testified that we had consulted with them and that the consultations was recorded, and thereafter the investigating officer brought to them a statement which they then confirmed and signed.
Okay.
All said, my lady, it is submitted that after all the arguments have been finalized, and if there is still uncertainty in the court's mind about certain facts of law or facts with which we can assist, a further argument at that stage will be of much more assistance to the court than us merely repeating the argument, the written argument as filed on case lines. As the court pleases, my lady, I have at this stage no further argument.
Okay, thank you. Mr. Sim, I see you have been scheduled to start at after the tea break. Can I just find out if you want to proceed? Or do you want us to take a break, but we have just started? Are you ready? I don't want to take you.
Mr. Late was much quicker than even I expected him to be, but I'm ready to proceed now, and I think we should make use of the time.
Okay, all right.
Make use of what just to say that, my lady, that our argument on behalf of the families that we represent will be divided between myself and my learned friend, Ms. Nasreen Rajab Badlander.
Yes.
So we propose to divide it roughly half and half. So an hour for me and an hour for my learned friend.
Yes.
But because my learned friend is going to be dealing in some detail with specific deceased, it's possible that she may run over, and I'm just letting that.
You can use the time as you have the time now. Maybe it can assist her in case.
Indeed, so my lady. Thank you. So, my lady, then what we propose to do in dividing the argument is we'll start. I will begin. I'll address the following.
But before you do that, isn't it because now I've got the heads and they are more comprehensive? I don't want to limit your arguments, but I don't think one would regurgitate what is already there, because the purpose is to assist the court at the end of the day to understand your heads, isn't it?
That's correct, my lady.
Yes. So we must.
But yes, but there is, because the heads are so long.
Yes, it's better to assist.
We do need to highlight so that we can help the court to process the heads. But it is neither of us intend to regurgitate the contents of our heads of argument, but there's certain things that are appropriate in oral argument to emphasize, we would submit.
Okay.
So, my lady, I will try to, to limit my submissions to those that we have considered to be crucial.
Yes.
I'll address the following issues. The first is the test to be applied.
Yes.
Inquest. The second is to dispel two assumptions, contentions that arose in these hearings. And the first contention is that the deaths were natural. Deaths were normal, given the population.
There was something wrong. I hope you noticed that you were frozen. Yes, continue.
I didn't notice that, my lady.
Yes,
So the two assumptions that I hope to dispel. The first is in relation to the deaths being classified as natural.
Yes.
And the second is in relation to whether these deaths were in the normal course for mental health care users whose life expectancy is typically lower than the average population. I will then thirdly address the evidence as regards Ms. Mahlangu and her role in the transfer of mental health care users from Life Esidimeni.
Yes.
Fourth, I'll deal with the evidence regarding Dr. Manamela and her role. And when I'm done with that, my learned friend will take over to deal with Ms. Mube in the context of Precious Angels and the deaths that occurred at Precious Angels.
Yes.
And then the other 5 deceased who we have focused on, who died of other injuries for our argument. What I wish to say is that by focusing on 10, my lady would have seen from our written submissions that there are 10 deceased that we focus on. But we should not be misunderstood as suggesting that there is no basis for findings against in relation to any of the other deceased. We simply did not have the resources to comb through each docket and obtain expert opinion based on the dockets. So the dockets that we've analyzed, those 10, are relatives, sons, daughters, sisters, brothers of the families that are represented by Section 27, those 10 deceased. By way of background, very briefly, my lady.
Yes.
Permit me to remind the court as to why we are here. The arbitration is well known. We need not traverse everything that took place in the arbitration. But in the candid words of Justice Moseneke, in the opening paragraph of his award, he said, "This is a harrowing account of the death, torture, and disappearance of utterly vulnerable mental health care users in the care."
I think something is happening. I don't know with your, something is not right, because there are certain things that you say that we can't hear.
Milady, are others experiencing the same problem? If so, I will try to rectify it on my side.
Am I the only one experiencing that?
No, my lady.
No, my lady.
My lady, even on our side, yeah. There's a problem.
Yes,
There's the same problem already.
It's as if the picture freezes, well, picture and sound freezes.
Correct.
Right.
Yes, and we can't pick up what she's saying. It doesn't go for long, but we miss the opportunity of hearing everything that you say.
Lady, may I be permitted just a 1-minute adjournment?
Yes, please
to
do.
devices?
Please.
Thank you.
All right.
Lady, are you able to hear me better now?
Just continue. We'll stop you if we feel that there is a problem.
So, my lady, I'm not sure where I was lost. I referred to the opening sentence of Justice Moseneke's.
Yes, you were still on that. In fact, you were quoting him.
That's correct.
Yes.
And so the point is, what he was referring to was at least 141 deaths. The 141 that are the dockets in this inquest. In other words, what we were talking about is a mass atrocity. And we submit that it would not have occurred if it were not for the conduct of Ms. Mahlangu, Dr. Manamela, or Ms. Mube. Under the Inquest Act, this court's function is to make findings where possible, not of criminal liability, but findings of where criminal liability may lie. And I'll return to the test in a moment. This inquest is already 7 years. In August of 2016, Ms. Christine Umalo, the sister of deceased Virginia Machpela, requested the captain of the Atteridgeville police station to open an inquest into deaths that were taking place at Precious Angels. She received no satisfactory response. She approached Section 27 to assist. Section 27 followed up with a letter. It's all in the record, my lady. I can provide. It's not in our heads of our written submissions, however. but it is in the record. There was then a follow-up in September 2016 for a request for an urgent inquest. And needless to say, nothing happened other than most of the deceased were buried without postmortems. This inquest has not heard from families as to their engagement with officials of the Gauteng Department of Health, what they witnessed in the drastic decline in health of their loved ones and their pleas for intervention. But they have been relentless in seeking justice, including through their participation in this inquest. That's by way of background, my lady. We, in our written submissions, we set out the evidence in relation to the 3 witnesses that we say there's enough evidence on for a case of criminal liability. The evidence leaders accept that there's factual causation established against at least 2, Mahlangu and Dr. Manamela, but that legal causation is not satisfied because of the remoteness of the conduct from the harm. We will argue that in respect of at least 10 deceased, there is a sufficiently close connection between the conduct of Ms. Mahlangu, Dr. Manamela, and or Ms. Mube, and the untimely deaths. So the first topic I said I would address is a test under the Inquest Act. My lady, this court is very, very familiar now with Section 16.2 of the Act and the findings that the court is required to make, including the likely cause of death and whether the death was brought about by any act or omission, prima facie, involving or amounting to an offence on the part of any person. The words prima facie, as we explained, were introduced in 1991, an amendment to the Act. That version has been interpreted by several courts. In Goniwe and others, the court said that the test is less stringent in inquests, and we must make sense of that. What the court said specifically is the following. Bearing in mind the object of an inquest, it is my opinion that the test to be applied is not the beyond reasonable doubt test, but something less stringent. In my opinion, the test envisaged by the Inquest Act is whether the judicial officer holding the inquest is of the opinion that there is evidence available which may, at a subsequent criminal trial, be held to be credible and acceptable, and which, if accepted, could prove that the death of the deceased was brought about by an act or omission which involves or amounts to the commission of a criminal offence on the part of some person or persons. This was repeated in subsequent judgments. We've referred to them in our heads of argument. We don't need to repeat it. All I'll say is that in the judgment of Todd versus Magistrate, Clan William and others, the court there said in these words, the standard of proof applicable in inquest proceedings is poles apart to the standard of proof applicable in criminal matters. And then they repeat the test that I've just articulated from the Goniwe judgment. So that's the ambit of the responsibility of this court based on 130 days of oral testimony, 40 witnesses, and a record of almost 55,000 pages. The findings of this court, of course, are not final. In the SCA judgment that we referred to in our written submissions, the Hurt and Carter case, the SCA said that having regard to the provisions of the Act and the nature of an inquest, the findings are never finally determinative. There are processes that follow, said the court, in relation to which there will be further interrogation. The court said in terms of Section 17 of the Act, the record of proceedings is forwarded by the judicial officer to the prosecuting authority Decisions are made thereafter, and a prosecution might follow or not. If a criminal trial ensues, a different evidentiary burden rests on the state. Further evidence will be produced and evaluated. That, my lady, quite clearly and plainly states the purpose of an inquest court and the duty of the inquest court. May I turn then into the two assumptions that I referred to that I wish to dispel? And the first is that the deaths were natural, or that they were not unnatural. I can really do no better than to quote from the experts who testified regarding the effect of recording a death as natural. My lady, some of these extracts that I will refer to are in the record, but they're not in our written submissions. If I may, I will provide the court with the references as I go through them. And the first is the evidence of Professor Leslie Robertson. And this is at page 54215, where the question was put to her on the meaning of recording a death as natural on a death certificate or medical report. And she tries to explain it by using the analogy of the cholera outbreak. And she says that deaths in that instance, for example, are from natural causes. But the circumstances of those cholera deaths are unnatural for our period in history. And then I quote what she says. She says, so I think that is the way to understand how these are described as natural causes, because it is a natural illness and the body fails to maintain life in the circumstances. But the circumstances of the whole process, with all the moves, is unnatural, especially for people vulnerable to illness. That specific quote, my lady, is at page 54216. And that must be true, like in the most recent inquest findings in the death in detention of Imam Harun. The inscription of cardiac failure as a cause of death is the end result of the torture that preceded it, and it cannot be regarded as natural. Professor Robertson also pointed out that the circumstances that precipitated a natural cause of death here was preventable. And that just because it is recorded as natural, she says, does not mean it is okay. Point of healthcare, she says, is to delay death, not to bring it forward. And that's important because these deaths occurred in the context of providing healthcare, in the context where these patients were in the care of the state. So she referred to specific examples, and these are relevant, as the court will see when we deal with the specific deceased. For example, she says at page 54217, interrupting chronic care for chronic medical conditions would contribute to earlier mortality. She says epilepsy was not written as a cause of death, but uncontrolled seizures are preventable, and somebody who has got epilepsy and who has been on treatment on medication, they should not be having uncontrolled seizures. And her words are, so that is a highly preventable cause of death. She says the same thing in relation to sepsis. As this court is aware, there are many deceased before this court where the ultimate demise was due to sepsis arising from bed sores. And what Professor Robinson said here is the following. She says, Sepsis, the same thing. Somebody
Which page is that now?
I'm
on 54217.
54136.
54136.
She says, sepsis, again, the same thing. Somebody who has got dementia, who is bedridden and is vulnerable to developing bed sores, and they become septic, that person will not cry out for help because they have got pain from the septic bed sore. They are not going to demand the care and recognize that this bed sore is getting worse, I need care. They are reliant on the staff member or the nursing care to recognize that there is a bed sore developing. We need to massage the area. We need to turn the person. We need to change the positions. We need to care for them to prevent the sepsis occurring. So cause of death might be sepsis. It is natural, but it is preventable and it has got to be prevented. That's what Professor Robertson says.
Mm.
The same is confirmed in the testimony of Dr. Talatala, and particularly in his analysis of the 10 deceased and the circumstances of their deaths. So much then for the assumption that the deaths are natural. The second assumption is that the deaths that occurred are normal in the population of vulnerable mental health care users, and that it isn't dissimilar to the rate of death that occurred in Life Esidimeni, particularly during the winter months. That, I think, was very clearly dealt with by Professor Robertson in the article in which he analyzed all of the data. I think it was the legal representatives for Ms. Mahlangu who put up tables that showed death at Life Esidimeni over the period of certain years. There was no analysis that was provided, and there was no context for those deaths, how old the deceased were, what the cause of death was, and so on. There was also an argument that the reason that so many mental health care users demised in this case in June is because it was winter. Professor Robertson very clearly dispelled this. She says that this, my lady, at page 54297, she says the stress of the move would have been enormous, and the capacity to cope with it and to process it psychologically would have been very limited. That is why they were in this kind of care setting, because they actually found it difficult just to live in society, because society is not adapted for their disability. The primary reasoning and link, and I insert for the deaths, is with the transition process, the transfer from one care setting to another, and causing stress. It is triggering a cascade of stress response physiologically in terms of hormones and neurological responses and cardiovascular responses. And she says this would not have been picked up by an autopsy. She says, ultimately, the move of so many in a short period of time was not conducive to providing the necessary care, and that the mortality rate of this cohort was 5 and 6 times higher than what it would be in the general population. And that's important because she said that the standard that is accepted is the mortality rate to be double in the case of mental health care users, but certainly not 5 and 6 times higher. That reference, my lady, where she says that, is at page 54155. There was nothing normal, my lady, about these deaths. I turn then to Ms. Mahlangu and her role. The evidence leaders, paragraph 2.15 of their heads of argument say the following.
Which paragraph?
2.15. Page 54639 of case lines.
54639.
That's correct.
Yes, continue.
They say the following. When taking or supporting the decision to cancel the contract with Life Esidimeni and transfer or discharge mental health care users to the above-mentioned NGOs and home, the officials had done so, knowing that they put the health and lives of the MHCUs in mortal or serious danger, and despite explicit opposition and offers by knowledgeable entities to assist in the process, which opposition and offers were ignored, the officials foolhardily proceeded to push ahead at an unacceptable pace with the transfer and discharge, and thus possibly had caused the MHCU's unlawful corporal suffering and the precipitation of their demise. So that is a statement that's made in relation to the officials. So in relation to Ms. Mahlangu, what the evidence leaders argue essentially is that while this is true, the foolhardy approach, the rash, lack of appreciation of the warnings from knowledgeable people, the point that they want to make is she made the decision, but that she wasn't involved. Lady, I think there's some.
I think we're being interrupted. What is happening? Can you please mute your mics? You are disrupting the court. Yes, you may proceed. Please repeat because we were distracted. Yes. Okay, continue.
So what I understand the evidence leaders to be arguing is that while Ms. Mahlangu made the decision, she wasn't involved in the practical implementation and only became involved when deaths started. And that her actions were not inherently dangerous or having a known or predictable outcome. So although factually the actions caused the deaths, legally the results are not naturally or normally expected, and there was a novus actus interveniens, whether by Dr. Manamela or the NGO managers. So what the evidence leaders say is that despite the warnings, the result was unexpected, abnormal, and unusual, not foreseeable. My lady, what we say is quite the opposite. And indeed, the crux of this kind of argument is that essentially Ms. Mahlangu did not know that people would die based on the warnings because she wasn't warned of death. She just thought that there would be terrible suffering because they wouldn't receive proper care. That much is clear from the record, but no one said to her that that suffering would result in death. And my lady, we ask this court to reject that kind of submission. The first point to make is that Ms. Mahlangu made the decision. Although she tries to characterize this as a collective decision of the Premier's Budget Council, the evidence is to the contrary. And we submit that the evidence by Minister Creasy and the Premier at the time, Mr. Makura, is more probable. In fact, Minister Creasy in this inquest stressed again that there was no instruction at all to cut healthcare services. Ms. Mahlangu's counsel objects to the evidence that was led regarding the reason for the termination on the basis that it's irrelevant. So, you know, there were the evidence relating to the three possible reasons: deinstitutionalization, costs, and the Auditor General report. We need not go into that. What the record shows quite decisively is that none of those reasons pertained. And the point of it is to say that Ms. Mahlangu herself was unable to justify the need to move vulnerable mental health care users from a facility where they were receiving appropriate care and attention to facilities that were wholly incapable of providing adequate healthcare services. And Ms. Mahlangu did admit in the hearing that these patients were amongst the most vulnerable in our society and that she knew that their transfer required proper care. She also knew that the risks attendant upon the transfer. The record is complete with reference to evidence from experts in the employ of the department and outside the department, warning that there would be, and I quote, dire consequences if she persisted with the moves. She received these warnings prior to decision to terminate, through the process of the transfer and subsequent to the transfer. So all of these, and an important point is the first warning that were made, and the first very serious concerns of dire consequences that were raised with Ms. Mahlangu was in the context of the decision to gradually terminate the contract. So the 20% reduction in beds over time, over a period of 5 years. And it was in that context that these warnings were made. And they were not concerns that were articulated in vague terms. They spoke about relapses. They spoke about inadequacy of care. They spoke about the majority of the users at Life Esidimeni being not dischargeable, and so on. My lady's familiar with all of those warnings. We've been through it in detail in the inquest, and it's in our written submissions. We know that the MEC received the correspondence and read them. We know that because the MEC herself said so. Although she attempted to deflect this a little in this inquest, she was unequivocal in the arbitration that she read the concerns of the South African Society of Psychiatrists in the letter of June 2015, and that she realized the importance of the letter, and that she asked the HOD to deal with it. So in the face of the warnings, the MEC didn't request that the 20% bed reduction at that time be slowed down, or that the patients should be followed to ensure they were being appropriately cared for. Instead, she decided to speed things up, to terminate the contract with Life Esidimeni and decant all the users, some 2,000, within a period of 6 months, including the December holiday period. When the shock of that decision reverberated among the psychiatrists and the families, SADAG, the South African Depression and Anxiety Group, wrote to the MEC a very detailed letter questioning the process and the suitability of the NGOs. The MEC's response was, in an email to her officials in the department, it was, I quote, "Get our lawyers involved. These NGOs are dishonest, exclamation mark, exclamation mark, exclamation mark," close quote. She copied this email to her lawyer, Mr. John Tabecha. He was the same attorney that would represent the MEC and the department in litigation 2 weeks later to prevent the appointment of a curator ad litem to act in the interests of the mental health care users. When she was questioned in the provincial legislature about quality of care that the patients would receive, she assured the legislators that the patients would receive the same level of care. But she knew that to be impossible because she'd been told so many times by the experts and the employees in the department. And the issues of quality of care go directly to the care that the deceased that we will be dealing with eventually received and how it contributed to their death. The issues of quality of care were raised in Parliament on 3 occasions with the former MEC. In November 2015, in March 2016, and in September 2016. As we know, the response to the curator ad litem was rejected, the proposal. When speaking to the families, the former MEC reiterated her very determined stance. The decision was final. If the families wished for their loved ones to remain at Life Esidimeni, they should pay for it themselves. And she also condescendingly berated them and pointed out that in Brazil, the families take care of their mental health care users at home. So this was the conduct and the continual role of the former MEC. The warnings at that point continued. They went on into February 2016. As we know, Mr. Mosanogi made a very concerted effort to try to slow down, to halt what was going on, to ask for a year's extension, or to propose the purchase of the Life Esidimeni facility so that the users could remain there and in the care of the staff that were employed at the time, Life Esidimeni. This was rejected. And this is also important because why was the request made to the MEC? The request was made to the MEC because it was clear that it was only the MEC who could make a decision whether to continue or to stop or to slow down. Even Dr. Celebano testified as much. The response to Mr. Mosanogi was to question his loyalty. So this defeats the MEC's claim that the department officials made her believe that all is well, because these were the concerns that were put to her in a meeting with the officials, and the response on her part was to dismiss it. In the end, she agreed to extend the time period for moving the mental health care users by only 3 months, and she made it clear that it would have to be completed by then. And in fact, in the provincial legislature, she said that the provincial facilities would help to conclude the process even before the end of June. But there was no explanation for this rush and how it would be achieved. That was February, March 2016. The warnings kept going on. It went on into June. It went on May. Leslie Robertson, as we know, all of the emails we referred to, writing to the MEC that they were meeting with Dr. Manamela all the time, but they realized that she didn't have the power. That's what Professor Robertson said. That Dr. Manamela, they realized, didn't have the power to do anything, and that they were not going to get through, and that they needed to deal directly with the MEC. The MEC never met with them. She then continued to remain involved in the oversight of the project. Why do we say this? First of all, throughout the inquest, Dr. Manamela and other officials testified to their regular meetings with the former MEC. At 50981 to 50983, Dr. Manamela says that she, Mr. Mosanogi, and Mr. Tabane made many presentations to the former MEC. They did not hide anything from her. Moreover, the MEC chaired at least 5 meetings that we are aware of. 5 meetings between January 2016 and May 2016, dealing with this particular project. Those 5 meetings took place on 26 January 2016, 17 February 2016, 7 April 2016, 22 April 2016, 13 May 2016. Those are the ones that we are aware of. This is precisely during the critical period of the implementation of the original decision to terminate the contract. We also know that subsequent to this, on 5th of August, a final project report was presented to the former MEC. That was a report that showed the lowlights and the highlights. So on 5th of August, even then, the former MEC knew from that document, that 5th August final report, that there were these lowlights. What were the lowlights? That there were debts, that users were not being grouped according to needs, that there were lack of assistive devices in NGOs, lack of individual progress reports, expired food, lack of cleanliness, shortage of medical equipment, insufficient staff due to non-payment, lack of clinical staff, insufficient blankets, lack of ARVs, overcrowded conditions, and on and on. Ms. Mahlangu acknowledged in her testimony that the concerns or the lowlights that were, as they were described in that report, she acknowledged that they were serious, but she didn't report any challenges to the Gauteng legislature. She assumed that the issues were being dealt with, and she didn't follow up. While the report proposes actions and recommendations to resolve the issues, she says she can't remember if she followed up with the team and whether they were resolved. By the point of that report in August, 5 August 2016, 60 patients had died. A further 80 would still die. Amongst those are Virginia Machpela, who died at Precious Angels on 15 August 2016. Mr. Christopher Makwoba, who died at Precious Angels on 3 July 2016. Mr. Terence Chaba, who died at Pretoria West Hospital on 15 August 2016, after being transferred there from Precious Angels. Mr. Daniel Charles Josiah, who died at Precious Angels on 8 August 2016. Mr. Matlakala Motsahai, who died at Kalafong Hospital on 26 August 2016 after being transferred there by Precious Angels. Ms. Deborah Petler, who died on 26 March 2016 at Takalani Home. Mr. Franz Decker, who died 7 November 2016 at Kalafong Hospital after being transferred there from Tepong NGO. Mr. Charity Ratsoso, who died on 11 July 2016 at Mamelodi Hospital after being transferred there from Anchor NGO. Mr. Kuketso Christopher Mokharane died on 15 June 2016 at Rebafeni. Mr. Vuyo Aaron Kondwane, who died on 7 February 2017 at CCRC. When the first wave of deaths had been recorded and not yet in their full numbers, Section 27 wrote to Ms. Mahlangu to inform her of deaths. At that point, just at Precious Angels alone, there were 7 known deaths. Her response to the letter was, "Thank you, Sasha, we will revert back urgently." But she never reverted. Ms. Mahlangu's evidence later changed. She said she raised the issue with Dr. Salabano, and he said there was little that could be done about it. She can't remember whether she responded to the letter or not. So throughout this process, we see, one, that Ms. Mahlangu knew the risks. She knew what was going wrong. She was involved in meetings and discussions and correspondence at all the critical and material times of the transfer of the users and after. She had more than ample information to know the disastrous consequences of the decisions, of her decisions. Although Ms. Mahlangu would like to distance herself from both the decision to terminate the contract and the process of the move of all the mental health care users out of Life Esidimeni, evidence shows otherwise. It shows that, in fact, she was core to the decision being taken and to the implementation of the decision. My lady, we then wish to say that we don't want to repeat the submissions in the written our written submissions, but I suppose the core issue for this court to take away is that the warnings were so serious that to act the way Ms. Mahlangu did in the face of them was more than unreasonable. And it could not be said that she could not foresee the consequences of her conduct. And I think that the point that's been made in relation to legal causation and this plea by Ms. Mahlangu that she did not foresee death is really of no help to her. It's not necessary, as we know, for the foresight to correlate exactly with how the person eventually died. It is enough that the death was foreseen for liability to arise under causation. Mental health care users were placed in the care of the state. It was her duty. She was an MEC for health. She was not the MEC for finance or any other portfolio. She was the MEC for health. It was her duty to safeguard those users from ill treatment and death. The intervening conduct, in this case by Dr. Manamela and Ms. Nube, in relation to our deceased, wasn't independent conduct sufficient to amount to a novus actus. It flowed naturally from Ms. Mahlangu's conduct. I'm not sure that we referred to this case, my lady, in our written submissions. May I provide the court with the reference? It's Minister of Justice versus Stransham Ford. And it's 2017 dash Ford.
Yes.
It's 2017, volume 3, SA 152, and it's a decision of the Supreme Court of Appeal. And my lady, the context of that case was about physician-assisted suicide and whether that would amount to murder or culpable homicide, where the criminal liability could flow from physician-assisted suicide and what the current state of our law says about it. That's what the context of that case was. But in the context of understanding the principles of our criminal law, the SCA referred to a judgment by former Chief Justice Steyn, the then Appellate Division, where he considered this topic of suicide and where someone contributes or whose conduct facilitates the suicide. And this is what the SCA quotes from that judgment. I think it was a State versus Grootjong judgment. And it was a paragraph 48, where the SCA says, Steyn CJ went on to explain that the fact that the immediate cause of the suicide, immediate cause of the death rather, is the act of suicide, does not necessarily interrupt the chain of causation between the conduct of the accused person and that person's death, so as to free the accused from criminal liability. In other words, not every subsequent event that leads to a particular consequence is to be viewed as a novus actus interveniens, an intervening cause. To have that effect, the intervening cause must be a completely independent action in the sense of being separate from and unconnected to the earlier conduct. We submit, my lady, that that is a principle that this court should be considering and should be applying in considering the facts. To conclude on Ms. Mahlangu, then we say that she's criminally responsible for the death of the mental health care users, the 10, because she took the decision to terminate. She insisted on its urgent implementation. She failed to stop implementation when she was warned on many occasions by her own officials and specialists in the field. She had the power and the knowledge to prevent the deaths, but she did not do so. Question of legal causation, my lady, is obviously the subject that will occupy this court in its judgment. And it is so that there isn't any legal system that permits liability without bounds. In the case of Mashongwa versus Prasa, it's in our heads of argument. The court said that it is universally accepted that a way must be found to impose limitations on the wrongdoer's liability. It depends on whether the harmful conduct is too remotely connected to the harm caused or whether it's closely connected to it. When proximity has been established, then liability ought to be imputed to the wrongdoer, provided policy considerations based on the norms and values of our Constitution and justice also point to the reasonableness of imputing liability to the defendant. We submit, my lady, that the norms and values of our Constitution require nothing less than what this court is asked to do, not to find Ms. Mahlangu criminally liable, but to find that there is sufficient evidence that she is responsible for the deaths. Her liability will be determined by a criminal trial, and she has all the opportunity at that point to make her defense before the trial court. My lady, that concludes my submissions on former MEC Mahlangu. I'm now going to be covering the conduct of Dr. Manamela. I see that it's 11:14. Perhaps this would be a good point to take the tea adjournment.
All right. The court will take a tea adjournment now. We'll resume at 11:30. Thank you.
The court pleases.
May it please the court, my lady.
may it please the court. My lady, I'm now going to address the role of Dr. Manamela. And again, as I did with Ms. Mahlangu, I'll begin with what the evidence leaders, the gist of their position on Dr. Manamela. So what the evidence leaders say is that factually, the deaths wouldn't have happened if Dr. Manamela didn't allow the moves into the unsuitable facilities, despite the warnings. But they say legally, starvation was not expected, or a natural result, despite the position that the department, they specifically refer to Precious Angels, despite the position that Precious Angels was put in. And the same would be so for the other NGOs that we are concerned with our 10 deceased, that despite that, it could not have been expected. And it wasn't clear on the facts that there was no food, and that it can't be proved beyond reasonable doubt that the placement legally caused death. Because she could not have known, or a reasonable person would not know that the deceased would face starvation. And even if there was some foresight, it would have been expected.
Just a second, please, is it Ms. Morale? If this person can just remove her camera, please. We don't want to see you. You are not addressing the court. I don't know who this person is. Thank you. Continue. Now she's coming back. I don't know what's happening. Even you are distracting us. We don't know you. We don't want to know you, please. Thank you. Something is wrong with Karina Morale. Is it Mr. Pihlela? Please just check what is happening. Maybe they're the people who distract us. Continue.
So,
yes,
okay.
Let's just ignore her and continue. Yes.
So the argument was that even if there was foresight, the facility would have been expected to take steps to prevent starvation. But my lady, first of all, with respect, we say the evidence shows the exact opposite. There's nothing fanciful or remote about the consequences of Dr. Manamela's actions, because she knew what the conditions of the NGOs were, and she knew the level of functioning of mental health care users. And, Dr. Manamela's testimony was evasive and contradictory. She constantly attempted to deflect the questions by providing lengthy, irrelevant, and at times incoherent answers. But that said, there is significant evidence regarding her reckless role in the fate of the deceased. Although she didn't make the decision to terminate the contract, at no point did she object to the decision on the basis of the practical impossibility. In her words, in her testimony before the court, she said at the time that the decision was made, there were only 116 beds available in NGOs. And she said it was practically impossible to implement.
Yes. Apologies, continue.
It's of great importance
think you're having a problem again.
highly
You are having that problem. It keeps on coming again now. Can somebody alert her, please?
I think she's even frozen now, my lady.
She is. And now it takes much longer than before.
I'll exit and return, my lady. My apologies, my lady. Can you hear me now?
Yes, please just check and make sure that you are not interrupted again. You were frozen most of the time. You might have to check what is the problem now.
Changed devices, my lady, and I thought that it had improved, but we'll keep a track if it happens again. So, my lady, if I can just then return to where I think I left off, which is...
I'm not sure whether you'll succeed because already I was seeing something. All right, continue. Let's see.
Am I still breaking up?
No, for now there is no problem. I'm saying when you were trying to explain yourself, one could see that there was something wrong again.
Oh, my apologies.
Okay, continue. Let's see. Perhaps see.
I want to just try to get back to where I was, where I left off, and the point I was making at
the point was you're saying that while Dr. Manamela was not part of the decision to terminate the contract, she did not object. That's where you were. So you're trying to explain that.
I'm indebted to the court. My lady, she said that she did not object, but she also testified that she knew that it was practically impossible.
We can hear now. She knew that
it was practically impossible.
Okay.
And that there were only 116 beds available in NGOs. It's also of important this hearing that Dr. Manamela is highly qualified in the field of mental health. She has a PhD in psychiatric nursing. She was the most senior official responsible for mental health services in the Gauteng province for 7 years. The test of reasonable foresight in her case is therefore higher. She has special knowledge above the norm, more than a layperson, and she expresses to be an expert in psychiatric nursing. She was also the de facto leader of the project. The role was described as deputy project manager, but she was a de facto leader because Mr. Masanoki did not have any knowledge and expertise in the field of mental health. His role was in relation to the logistics, administration, and management. She also admits that she was responsible for creating the NGO spaces for all of the mental health care users that were transferred out of Esidimeni. She chaired meetings with her own officials and prospective NGOs. She engaged with stakeholders like SADAG and the families. As an expert, she knew the dangers of transferring patients chaotically to places that were ill-equipped and inexperienced. it was Dr. Manamela who coined the term marathon project. As with Ms. Mahlangu, there were repeated warnings before the termination of the contract with Life Esidimeni and after. And it's important because it was already clear to Dr. Manamela that there were insufficient suitable NGOs, and that it was highly unlikely that the mental health care users would receive the level of care they required in the NGOs. And she knew that the district health services could not be relied upon to care for mental health care users and to fill the gap for NGOs who didn't have sufficient skilled staff. None of this should have come as a surprise to her. In brief, I remind the court of what Dr. Manamela was warned of and when. March 2015, Dr. Manamela convened a meeting with senior psychiatrists and with Life Esidimeni management and the mental health directorate staff. The clinicians raised multiple concerns, it's in the minutes, and they refused to participate in the process. Again, this was at the point of the gradual reduction. They refused to participate in the process as it was proposed to them because they stated that it was morally and ethically incorrect. 1 month later, in April 2015, Dr. Madikwe submits a memorandum detailing concerns, and the language that he uses is that it would have, and I quote, a devastating impact on the health and social well-being of the mental health care users. Dr. Manamela admits receiving the letter and that she admits that the contents of she agrees with the contents of the letter, but she says that she asked the clinicians to direct it to the former MEC. She also testified that she agreed with the letter that explained that these users...
I'm going to stop you. Can you only hear him? I think there is a problem. Mr. Sibara?
Yes, my lady. We are really struggling to hear my lady senior.
Yes, I think she has been breaking and breaking and breaking. Mm.
Now, lady, that is not suitable for my argument if I'm not heard properly. So,
yeah, you might
now
have
she
to...
is frozen now. She's completely frozen now.
Sacha, please check what is happening there.
Lady, I've switched devices and changed the network.
Yeah,
I really hope that this
much
works.
better off now.
I'm going to take a step back, if I may, in light of the fact that I wasn't very audible.
Yes, perhaps you must do that.
I was discussing the fact that Dr. Manamela, as the head of the Mental Health Directorate, and as a specialist psychiatric nurse, was aware of the level of mental health services that are available in the communities in Gauteng. And I then went into the warnings. The warnings is because they were quite specific, and they were repeated, and she agreed with it. So I began by referring to the March 2015 meeting that she convened with specialist psychiatrists, the Mental Health Directorate, and Life Esidimeni, where her own psychiatrist refused to participate in that gradual reduction at that point in time, because in their view, it was morally and ethically incorrect. In April 2015, Dr. Madikwe said to her that the move would have, I quote, a devastating impact on the health and social well-being of the mental health care users. Dr. Manamela admitted to receiving the letter. She said she agreed with the contents of the letter, but she says that she asked the clinicians to forward it to the former MEC. In June 2015, the concerns were raised, and it was pointed out to her that these users were placed in the chronic 24-hour facility because of the severity of their psychiatric disorder and their level of functioning. She admits that she did not respond to the concerns of. She admits receiving it, but she didn't respond. She did, however, respond on 22nd September 2015 to the clinicians, but in that letter, it was only to inform them of the termination of the contract entirely. In October 2015, SASOP said to Dr. Manamela that, and I quote, "They are deeply concerned that the community mental health services were not sufficiently developed to accommodate the mental health care users that were to be transferred." Dr. Manamela testified that she agreed that the NGOs are not equivalent to Life Esidimeni in terms of staffing or equipment. Her defense really was that it was fine if the NGOs couldn't provide the care that the patients were receiving at Life Esidimeni, because the NGOs could have access to the district health services. But that's no answer, because as Professor Robertson informed Dr. Manamela, the district health services were not capable of providing the requisite specialist level of care. And she pointed out, Dr. Robertson, if patients relapse and need admission, they would first need to be stabilized psychiatrically, rather than what she called that the district health services were underdeveloped.
You were frozen. So, I just wanted to alert you that it happened again just now. I don't know.
I'm at a loss because I changed devices and changed the networks, my lady, and all right.
Let's continue. Perhaps you might have to repeat the last part. I don't know whether that was properly captured on record.
So the last point I was making, my lady, is that it's no answer to say that even though NGOs were not sufficiently skilled or equipped, that they would have access to the services in the district health services, because the district health services, Dr. Manamela knew, could not provide the level of care that was required to those mental health care users. There's no district psychiatric services available, as Professor Robertson testified. Of course, Dr. Manamela would know this because she was the head of the mental health directorate for the province. So that answer doesn't aid her. With regard to the number of users that were discharged at once, read that the caregiver to user ratio is very important for quality of care. But she said that, and she said this, my lady, because I'm not sure that this is in our written submissions. It's at page 51140.
Page
51140. She said that, that's correct. She said that Professor Robertson only raised this issue of the caregiver to user ratio in May 2016, and that users were already being placed. And she testified that if Professor Robertson had brought the concern to her in April, in her words, she says, I would have taken a team to check what she is saying. With respect, my lady, it's a shocking response.
Where is that? I'm on the page 51140. Oh, okay.
So her testimony was that she should have been told a few weeks earlier, and then she would have taken a team. And that's a completely unacceptable response, because not only should she, as a mental health director, she says she would have done something a few weeks earlier, and she says nothing about why she did nothing after Professor Robertson raised this. So that also is no answer. In September 2015, again, there was a meeting with the hospitals and the staff of the Mental Health Directorate. The minutes are clear. The department's own experts said that the NGOs would not be able to care for the mental health care users because they didn't have the level of experience that's required. That was 21 September 2015. And then it went on and on. October 2015, there were more concerns. 30 October 2015, SASOP wrote. 26 November 2015, SADAG wrote. 16 December 2015, the litigation for a curator. All of this, all within Dr. Manamela's knowledge. In fact, she was the person who was responsible for providing the information in the court case and the answering affidavit as to why everything was fine and the curator at Lighton was not necessary. In June, and from the letter of theirs on 2 June 2016, this is what they said: extremely high rate of negative.
Sorry, my senior.
Yes,
sorry,
Mr. Sibero.
There are times where my senior, she's breaking at very crucial
just now,
moments.
yeah, there was
at very crucial moments, and we are not capturing submissions very well. It started when she said that she was the one who was providing information to populate in the opposing affidavit. Yes, I think there was a breaking there somewhere there. If she can just recap that part.
Correct.
Thank you, Mr. Sibara. I was saying that Dr. Manamela I think it was Dr. Lebete who deposed to that answering affidavit, but he said it was based on the information that was provided to him by Dr. Manamela. And then I moved on to June 2016, a letter from SADAG in which, and I quote, they warned of, I quote, extremely high rate of negative outcomes, including relapse and deaths. That letter, and Dr. Salabano.
Yes, just there was something wrong also. You can just repeat, but you might have to check
again.
your devices. Yes, again, please.
My lady, in 1 second I'll join on yet another device.
Please do. Just before you proceed, I'm just going to stick to the time frames here. You indicated that your other colleague will be proceeding. Will she be proceeding when? After 2 or? But then if it's after 2, oh, I don't know. Just check because it's now about 4 minutes to 12 o'clock. I don't know whether the aim was for her to start when, because in the schedule you didn't indicate as to whether you're going to share the submissions.
That's right, my lady. We isn't indicated. We have half an hour after lunch, 2 to 2:30. But I'm hoping that my learned friend will begin before lunch.
Okay. No,
so
that's fine.
I hope to wrap up within the next 15 minutes.
All right, continue. I just hope we're not going to encounter problems.
I hope not, my lady. This is a third device and a third network.
Okay.
I'm doing the best I can with the circumstances. My lady, I want to turn to the aspects of the evidence relating to the licenses that Dr. Manamela issued.
Yes.
So, and the ones that we are concerned about in relation to the deceased that we focus on are Precious Angels,
yes,
Sapong, Reba Feni, and Takalani. All of these NGOs, except Takalani, were new startups. They had no prior experience in caring for mental health care users at all, let alone mental health care users with the severity of psychiatric and intellectual disorder and physical illness as those that were discharged from life Esidimeni. The 10 deceased that we focus on died in these NGOs as a result of the neglect and incapability of the NGOs to care for mental health care users. Now, Dr. Manamela's admissions during her oral testimony are quite damning. These are the admissions. As I said, that she knew that there were only 116 beds available.
Yes.
In NGOs in the community. 2, that she was responsible for ensuring that the places to which the users would be transferred met the minimum standards, the minimum norms for quality of care. She is responsible for that. She knew that NGOs such as Precious Angels were not adequate, yet 56 users were transferred there, resulting in 20 deaths. Why do I say that? Dr. Manamela, the basic requirements for licensing health facilities under the Mental Health Act was put to Dr. Manamela. Those basic requirements appear at page 30967. She admitted that those are the requirements. Those requirements, it's a lengthy list. It includes such things as that there must be, in order for a license to be issued, there must be a signed and dated copy of the current service level agreement. There must be an NPO certificate. There must be proof of bank account. There must be latest audited financial statements, business plans, admission criteria for users, etc., including a map denoting the address of where the NGO is located. None of those were met, those requirements. She admitted that the NGOs met these requirements. She admitted that she didn't verify that the NGOs met these requirements before signing the licenses. She defends this by saying that it was her team's responsibility to do site inspections, and that given her role and responsibilities, she couldn't run around, the province inspecting NGOs herself. But that's not what was required of her. What was required of her was to check that all the relevant information necessary to show that the requirements for a license were met, that all that information was before her. She should have checked that there was a service level agreement in place. She should have checked audited financial statements. She should have checked that there was a map denoting the address, etc., etc. She admits that she didn't do so, that she just relied on the say-so of her staff. So she signed the licenses without checking those documents.
Was that her responsibility to check? Was it not something for the district?
It was absolutely not something for the district to satisfy them. It was their job to conduct the groundwork and to put all of that information together. That was their job, to put it all together. They then, the person responsible, and remember Dr. Manamela said she was the one who was the responsible person for signing licenses.
Correct, yes.
She accepts that there are basic requirements that have to be met. And then she says, but she didn't check. She just said, is it met? And she signed. Right. Now, for a license of this significance, not to ask the staff who had done the site inspections, not to verify that there were these documents in place, was an abdication of her duty under the Act. It was her responsibility to issue the license. Whether it was her responsibility to do the groundwork is a separate issue. And she did not satisfy herself that the requirements were met. And in fact, there is evidence from her staff that they were not able to meet those requirements because of the rush. And I'll point to parts of the record where this becomes apparent. Not least that Dr. Manamela admitted that the audit of NGOs like Precious Angels and Anchor were conducted after the licenses were issued and long after the patients had been transferred. So how could a license be issued when there was no audit conducted of those particular NGOs? She also testified that there was in some NGOs not sufficient food because they received funds from the department late, and that NGOs couldn't pay their salaries and the staff, and then the staff absented themselves from work. She acknowledged that there were NGOs reporting to her that when they took patients to the clinics, that they could not be attended to because of overcrowding in the clinics. That is true of Precious Angels, Tsapong, Rebafeni, and Anchor. We'll show that in connection to the deceased. At least 4 witnesses who testified in the inquest, Ms. Gordon, Ms. Jacobus, Dr. Lenkwane, and Ms. Sinello, testified that Dr. Manamela told them to place the users, even though the audits hadn't been done and that there were problems, because the problems would be dealt with later. And that is understandable because of the rush. There was no way that the requirements for licensing and auditing and ensuring that those NGOs were suitable could be met in that space of time. So in relation to Precious Angels, Precious Angels didn't even have a license to accommodate users in the Attridgeville and Danville house. There was no license. She agrees that she received the audit report on the abysmal conditions at Precious Angels on 20 July 2016. Her response was, and I quote, "It doesn't bear pleasant tidings, but we were not told that deaths had taken place." But she said, and so, in other words, she knew that things were very bad, but again, she didn't do anything about it. She says that the reason why she said she thought about moving the patients from Precious Angels, but that Precious Angels told her that there was a place in Linwood where they could go to accommodate the users. That never happened. The service level agreement with the Precious Angels, as we know, was only signed on 16 August. This was long after patients had been moved, patients died. In relation to one of our deceased, Virginia Makapela, both Hannah Jacobus and Ethel Mube testified that Dr. Manamela was the one who said that Virginia Makapela should be taken to Precious Angels and that problems will be sorted out later. And that was in the context of a discussion about Miss Christine Tumalo, who is the sister of Miss Makapela, and they said she's a problem person. Dr. Manamela denied this. All 5 that died at Precious Angels were supposed to be discharged, were not supposed to be discharged to an NGO, according to their periodical report. All of our 5 that died at Precious Angels. In relation to Anchor, again, Dr. Manamela signed the license for California Heights. She admits that at the time she signed the license, she knew that there was no NGO at California Heights. She said, but the plan was to put the NGOs at California. So, in other words, she admits that she issued a license for a place where there was no NGO on the hope that things would come right. With regard to Reba Feni, she says that she signed the license for Reba Feni House. Yes, she signed the license for Reba Feni House 3. But Ms. Frida Ndlovu testified that she was wholly unqualified to manage the NGO, that no one from the department inspected the house prior to receiving patients, and she had no knowledge of the compliance requirements for NGOs. Mr. Tsetso Malebe, who spoke on behalf of Reba Feni as a whole, all 3 houses, he confirms that he called Dr. Manamela to say that lives were in danger because they were running out of food, because the department had stopped paying. He also said that they did not have the skills to care for the users that they received, and they didn't have sufficient staff. He made the decision to terminate the service level agreement, that the old service level agreement that he was relying on with the department, because of what he was witnessing and because he knew that he couldn't care for the users. In Sapong, she says again, she endorsed what she was told. She signed 2 licenses for Sapong on the same day for different number of users and for different categories of mental health care users. She contradicts herself later by saying that the audit reports are not provided to her, they're provided to the chief director, who is above her rank. But it makes absolutely no sense, and it is highly improbable, because the chief director is not the person tasked with issuing the licenses. Dr. Manamela is the person tasked with it. She also says that the consequences of not having a service level agreement in place means that the NGO can't receive funds from the department. So it all ties in. You sign a license, you don't know whether this is a brand new NGO, you have no prior experience, you know what the level of care is, you're a psychiatric nurse, you're the head of the mental health director, and there's no service level agreement, and you know they won't get any money, yet you send the users there. She also admitted that it was a rushed process. So in the light of all of those admissions of Dr. Manamela, we submit that on her own version, there is, as the previous inquest courts have held, and I just repeat, I quote what this test is, there is evidence available which may, at a subsequent criminal trial, be held to be credible and acceptable, and which, if accepted, could prove that the death of the deceased was brought about by an act or omission which involves or amounts to the commission of a criminal offence on the part of some person or persons. My lady, as with Ms. Mahlangu, we respectfully submit that this court should not shrink from finding that Dr. Manamela has a criminal case to answer.
I'm in chambers, so you must understand, and I can't lock my door. Yes, continue.
I'll repeat my last sentence.
I'm sorry about that. Continue.
Lady, what we are saying is that, as we have said with Ms. Mahlangu, that with respect, this court should not shrink from finding that Dr. Manamela has a criminal case to answer. She should not be protected from merely facing a crime. She too will have ample opportunity to defend herself. Lady, having set out the evidence of the involvement, choices and conduct of Ms. Mahlangu and Dr. Manamela in chaotically moving frail mental health care users with no regard to their best interest, to hopeless NGOs, simply as a means of putting them in a bed. They deserve to face the consequences. My learned friend, my lady, will take the court through the role of Ms. Ncube and then the evidence pertaining to the specific deceased and the link between their deaths and the three people that we say are implicated. My lady, at this point, may I request a 2-minute adjournment to swap over to my learned friend so that she can take over.
All right, okay.
As
that is good. Yes.
Good morning, my lady.
Good morning. Is it still the morning? I see it's...
Oh, sorry, it's the afternoon. My lady, it has been slightly chaotic. I've now moved from Ms. Hassam's chambers to my chambers a few blocks away. So I'm hoping that that this connection will be better. But I am working on a different computer, so you'll bear with me if I slow down a little bit.
All right. No, that's fine.
So, my lady, I am first going to deal with, as you've heard already, the evaluation of the role of Ms. Ncube, the owner of Precious Angels, and why we contend that this court must find that prima facie she has a case to answer before a criminal court. And then I'll turn to examine each of the 10 individual deaths, which we contend were caused by the conduct of Ms. Mahlangu, Dr. Manamela, and or Ethel Ncube.
Yes.
I am aware that my time is limited, so I'll try and be as brief as possible. And as your ladyship has already pointed out, our heads are quite comprehensive. They contain all the references to all the factual statements that I intend to make. But where appropriate, I'll try and direct the court to case lines references during the course of my address. Now, if your ladyship would like to follow, then in our heads, we start with the conduct of Ms. Ncube at case lines page 54974. You don't have to follow in the heads, but I give you that for purposes of your notes.
Okay,
now,
that's fine.
we know, we've now had many, many days of hearing, we know that Ms. Ngube was the owner and the director of Precious Angels. We also know that Precious Angels was a registered NPO. In fact, it was registered in June 2016, which is the same month, in fact, that Ms. Ngube received 56 mental health care users into her care. And she started operating a 24-hour facility for adult mental health care users. And then within 2 weeks of receiving those mental health care users, the first person in her care would die. And that was Mr. Christopher Makgoba. He died on the 3rd of July, 2016. Another unknown mental health care user would die 3 days after that, on the 6th of July, 2016. And what followed was a fairly consistent stream of deaths until January 2017. So what we see is a 7-month period where 20 mental health care users would die. That is approximately a third of all the mental health care users housed in Precious Angels under the care of Ms. Ngube. Virtually all of those mental health care users were emaciated, dehydrated. Many of them had pneumonia when they died. You'll find, my lady, the full document reflecting death and transfer dates at Precious Angels in the record at case lines page 37552. Now, as the court has heard, we're only focusing on 10 deaths. 5 of those deaths happened at Precious Angels, or were patients that were at Precious Angels. Their names were Christopher Makgoba, Terence Chaba, Virginia Magapela, Matlakala Motsoahai, and Daniel Josiah. So there were 5 deaths at Precious Angels, and then there were an additional 5, which I'll deal with in due course, who were not at Precious Angels. Now, in terms of background, we know that Ms. Ngube's background was not in taking care of adult mental health care users. In fact, she had an NGO that cared for children with intellectual disabilities in a daycare center. So it wasn't even a 24-hour center. And that was her experience. She had some accounting training, and she ran this NGO for children, daycare center, I should call it. But what we also know is that Ms. Ngube, during the course of running her first, I'll call it her first NGO, that was for children, she developed a relationship with the department, which was how she ended up receiving an invitation to be part of the Life Esidimeni termination meeting at West Corpies. So she had a 5-year plan, and that plan was to expand her daycare to include teenagers, adults, and old age programs, but still a daycare. So at this stage, that was her interest. But because she had this relationship with various officials at the department, they invited her to come to a meeting when they were looking for NGOs to house mental health care users as part of the Marathon Project. Ms. Ngube in her evidence also confirmed that Dr. Manamela was also aware of her and of her 5-year plan. She confirmed that she didn't know Dr. Manamela very well, but Dr. Manamela certainly was aware of the work that she was doing. She also knew Ms. Gordon, Ms. Lenkwane, Ms. Jacobus, so the department wasn't a foreign place to her, and these officials were not people that she didn't know. And all of this becomes relevant when we start looking at what Ms. Ngube's role was and what her involvement was in the deaths of these particular mental health care users. Ms. Ngube began by thinking that she would start an NGO under the Marathon Project for Children. But it quickly became clear when she went to collect mental health care users that she had to receive adult mental health care users. She raised her concern with Dr. Manamela at the time before she took patients, and Dr. Manamela told her that they were like children. Even if they were adults, they were like children. Ms. Ngube met with Dr. Wadwala when she went to receive mental health care users. He took her on a tour of the wards. He showed her the severe to profound intellectually disabled mental health care users. She inquired about their level of functioning, and Dr. Wadwala confirmed Dr. Manamela's response that the mental health care users' level of functioning resembled that of children. But of course, she conceded in cross-examination that even if their mental health was like children, they were in fact adults, and they required very specialized care. And Dr. Talatala testified that the fact that a person has a mental age of a child does not mean that they can be cared for in a home for children, because from a very practical level, they have adult bodies. They have different needs to those of children. But instead of refusing to take them because she wasn't adequately prepared or trained, on 23rd June 2016, Ms. Ngube accepted the first round of mental health care users. She accepted 22 male mental health care users. And you'll find reference to that at case lines page 48146. At the time that Ms. Ngube accepted these 22 male mental health care users, she had no professional nurses. This is undisputed. She had no psychiatric nurses. Her staff were mainly cleaners who had helped her with renovations to the Kalafong hospital premises, which she thought she would occupy, but ultimately we know she didn't. So that's the context in which she accepts the first group of patients. Now, we know that she ran 2 houses. She ran one in Danville and one in Attridgeville. The initial 22 male mental health care users were housed in Danville. Once they were there, it quickly became apparent that the department was not providing assistance or resources, training, food, payment of any kind that they had promised to her. So that became clear very quickly. As soon as she got the first round of mental health care users, it became very clear that what she thought was going to come her way in terms of resource and assistance was simply not happening. Notwithstanding this, on the 29th of June, it's about a week later, Ms. Ngube accepted more mental health care users. This time she accepted women who were at the anchor home. She was told that they needed to be moved urgently before the MEC visited, because if the MEC visited and saw that there were men and women housed together, there would be trouble. So she was called in to accept an additional, I think she said 7 to 8 women. Now, this was just the beginning. She continued to accept mental health care users until ultimately she had 56 mental health care users in her care. And these mental health care users had a variety of illnesses. They ranged from Alzheimer's, epilepsy, cerebral palsy, dementia, psychosis. And if your ladyship would like a reference to that, you'll see that in the transcript at page 48198. Now, Ms. Ngube testified that one of the promises from the Department of Health before she received mental health care users was that there would be an assessment team. And the assessment team would almost come with her or meet her as soon as she started to get mental health care users. And they would provide the NGO with assistance in assessing patients, looking at their medication, what were their dietary and treatment needs. And this was especially important to Ms. Ngube because she had no clinical experience on her own version. But we also know, and having heard the evidence, that the assessment team promised by Ms. Jacobus never actually arrived while the mental health care patients were at Precious Angels. Now, Ms. Ngube did not dispute that despite that, she was not prepared for adult mental health care users. She continued to receive people without an assessment once they got to Precious Angels. And we know from the evidence of Dr. Robertson that initial assessments upon transfer were critical, because if you weren't known, if your medication wasn't known, if your treatment plan wasn't known, how was it expected that you would be taken care of at the appropriate level? So we know from the evidence of Dr. Robertson that assessment was critical. That was not provided. Ms. Ngube realized that that wasn't provided, and yet she continued to accept mental health care users. It's also not disputed that at no point was Danville was the Danville Attridgeville houses where she housed the mental health care users licensed? She gave evidence that she had licenses for Linwood and Kalafong, but she did not have, it's not disputed that she did not have licenses for where the mental health care users were actually housed. And I'll come in due course to the argument raised by counsel for Ms. Ngube in relation to the licenses. Now, in her own words, I draw this picture for your ladyship because this is the context in which 56 mental health care patients were transferred. In her own words during her cross-examination, Ms. Ngube said, I quote, "I had no clue on running a 24-hour. And you'll find that on page 48131 at line 6. And the fact that she had no clue is perfectly evident by what came to follow. And we'll submit that when one looks at Ms. Ngube's conduct in continuing to take people, and when one looks at the conditions in which she housed people, which we'll come to, we know that she effectively was ignoring all of the information in front of her, that people under her care were in danger. We also know from other evidence that was led in this inquiry that when similarly placed, Mr. Titsetso Malebe from Rebafeni, he had the same reaction. He said to this court that he received mental health care patients and he realized that there was no assistance coming from the department and that he wasn't able to care for them properly. But his response was vastly different to that of Ms. Ngube. He tried to cancel his contract with the department, and in fact, he did ultimately. He immediately notified them that he could not do this, that he could not provide the right care for them. But Ms. Ngube did nothing of the sort. She kept going. She kept taking mental health care users and placing them in this horrendous position, which ultimately we submit led to their death. The houses that Ms. Ngube operated as a starting point were simply not suitable. They were not much more than buildings which people occupied. There are 2 reports of assessments done of Precious Angels, the 2 Precious Angels houses during this period, and those are important. Those 2 I call them visits. Those visits from the department officials to Danville and Attridgeville houses were on the 20th and 28th of July, 2016. And your ladyship will find those reports at case lines page 586 and 20423. So the first visit was on 20 July, 2016. And at the time that the first visit from departmental officials took place at Precious Angels, 7 mental health care users had died. The report itself showed very significant deficiencies in the Attridgeville property, particularly. These included that there were 15 female mental health care users at the property, with 3 in one room and 12 in another. They were in cot beds that were placed very close together. And your ladyship will recall that under cross-examination, Ms. Ngube described what a cot bed was. And she described it as bigger than a normal child's bed with metal sidings along the bed so someone couldn't fall out, but shorter than a normal adult bed. And in response to questioning about a cot bed, she said it wasn't bad because mental health care patients, and I'm paraphrasing, but mental health care patients generally were curled up. And so it didn't matter that the bed was short. That's an astonishing statement to make by someone charged with their care and with the care of people who ultimately were found with things like bed sores. We also know from the original report of Precious Angels that there were very few staff members, that they were not trained, and that there was not much food. And when Ms. Lenkwane gave evidence, she confirmed this, and she testified that, in fact, when she was there was no food at the center except for, quote, 1 or 2 cabbages. Ms. Ngube disputes this. but there's no evidence before this court to show what meals were provided to patients or that they were in fact fed. What we instead have is a series of emaciated, thin, dehydrated mental health care users. Then the second visit, which I referred to, there was a second visit from the department to Precious Angels houses, and that took place on the 28th of July, 2016. And that you can find the report at page 20423. Ms. Ngube was present, she confirmed during the visit. And the second report also recorded a series of deficiencies in the house. I'm not going to take your ladyship through them all. They are all listed in our heads, but to mention a few, the number of rooms was not enough for the patients. Some beds were too close to each other. The only personal space that patients had was on their beds. Doors couldn't be closed because the rooms were too full. The ceiling hasn't been fitted yet, so it was windy. Staff were utilized all for multiple functions, including security, cleaning, cooking, laundry, and patient care. So there was no specialized care. There was no reliable patient identification. And there was no other rails or other mechanisms for functional patients to be able to move around safely. And the list went on. Now, when asked about this under cross-examination, Ms. Ngube's only response was that they had improved on the cot beds and that they had made other changes to deal with the concerns raised and that they took pictures to send to Dr. Manamela. And you'll find that at case lines page 48659, line 16 to 20. But the bottom line is 56 mental health care users were housed in conditions which fall far short of any expectations one may have of an NGO that has to care for vulnerable mental health care users. So it's not good enough to say that sometime after the end of July, when mental health care patients were already being housed in Precious Angels, that Ms. Ngube started to fix some of the things. It's also not clear to us in the evidence what she fixed or that it was appropriately fixed. What we know is that these houses that she housed patients in were severely lacking. And when 20 people die in an organization like this, that's 1/3 of the people there. One must pay attention to how the facility was run, who ran it, and what condition it was in. Now, if I may say something briefly about the staff that Ms. Ngube employed, Ms. Ngube was somewhat contradictory in her evidence in relation to staff. She initially said several times that all of her staff had home-based care certificates, but when pushed, she then clarified that some had home-based care certificates and some did not have any training. And she said that the ones that had no training had been cleaners for her when she was trying to renovate the Kalafong facility. And one of those people was Mr. Nofile, who gave evidence. Mr. Nofile was a former employee of Precious Angels. He was originally a cleaner, and then Ms. Ngube asked him to come and care for patients because he had apparently had an elderly relative that he cared for at home. He had no training. He said in his evidence that he was promised training on how to take care of mental health care patients because it was not something he knew how to do, and it did not come. He talked about staff enduring extended shifts without any days off, not being paid, and he talked about the fact that because of those conditions, those working conditions, many staff left. So there was a turnover of staff. Now, your ladyship will just bear with me for a minute. I want to move on to the issue of licenses, if I may. Now, Ms. Ngube was aware, and this was made clear during her cross-examination, she was aware that she was operating these facilities without a license. It's not disputed that she never had a license to operate the Danville and Attridgeville properties. And if your ladyship would like a reference for that, it's case lines page 48204. One of the arguments raised on behalf of Ms. Ngube in her counsel's heads of argument is that it doesn't matter I hope I'm correctly summarizing this argument, but if not, Mr. Pitlela will correct me when he's up. The argument, as I understand it, is it does not matter whether the facilities at Danville and Attridgeville were licensed, because there was a license somewhere for a Linwood property and for a Kalafong property. So he says the address is effectively a red herring. The address is, or I should say, it's irrelevant because there was a license somewhere. Now, that is simply not correct. A license, one doesn't need much to accept this, but a license reflects that a particular facility was checked, that it was assessed, that it met the requirements to house a particular number and type of mental health care users. And we know from the licenses that are in the record that they were only for a particular period of time. So it wasn't an open-ended license. All of this was for a reason. And that reason is to make sure that for licenses to be effective and valid, there is a continual assessment of compliance. So the address is therefore a critical component of the license. It doesn't help to get a license for a non-existent NGO in Linwood when you're housing mental health care users in a completely different property in Attridgeville. So we would submit that argument in relation to licenses made on behalf of Ms. Ngube is entirely without merit and must be rejected. The other argument that is made on behalf of Ms. Ngube is that Ms. Ngube is simply a director of an NGO, akin to a director of any other company, and that it is misleading to call her owner. It's also argued that she cannot be legally liable for the fact that mental health care users died in her facility or for the way in which they were housed, cared for, or treated. Okay. Now that's just incorrect. It's incorrect as a matter of fact, and it's incorrect as a matter of law. We know from the facts that Ms. Ngube never disputed that she was the owner of Precious Angels. She did say that she did not care for individual mental health care users, but that in itself does not remove her from scrutiny. We also know from the evidence that Ms. Ngube was very hands-on. She may not have dealt with each individual mental health care user's daily routine, but she dealt with the department from the outset. She knew Ms. Jacobus, Ms. Gordon, Dr. Manamela. She was used to engaging with the department. She herself went to collect mental health care users on each opportunity that she received them. She herself went to Randfontein to assess the mental health care users that she'd be receiving. She spoke to Dr. Wadwala about these particular kinds of mental health care users, what their condition was, what they required by way of treatment. She had agency. She was responsible for Precious Angels. While she employed others, we accept she may have employed other people to do the daily care for them. They were not properly trained or supervised, but she did employ others. But at the end of the day, she was the one who made the decision to keep accepting more mental health care users. She was the one that sourced houses, borrowed them from her uncle, found places to put people and put them in those houses that she ran. Not once in her evidence before the arbitration or before this inquest did Ms. Ngube point to anyone else who managed Precious Angels or anyone else who was involved in the decision-making. In fact, some of the departmental reports referred to her as the manager, and that would be correct. She may have been a director, but she was the person in charge of Precious Angels and who operated it. So to ask this court to draw an artificial distinction and pretend that there's some veil that may not be pierced, as in the case of a company, is simply not correct. For one thing, we're looking at Ms. Ngube's conduct. We're not looking at the conduct of Precious Angels. We're looking at Ms. Ngube's conduct, which is at issue here. In any event, even if it was the conduct of Precious Angels that was issue, we know that our law permits the piercing of the corporate veil in certain circumstances. And if your ladyship wants a reference to one of the locus classicus in this field, and then its Cape Pacific Lubna controlling investments. It's not referred to in our heads of argument, my lady, because this argument arises from the heads of Mr. Pihlela. So it's Cape Pacific Lubna versus Lubna controlling investments, and the citation
Pacific
Lubna, L-U-B-N-E, sorry, Cape Pacific versus Lubna, L-U-B-N-E-R, controlling investments. And the citation is 1995, volume 4 SA, 790, Appellate Division, as it then was. And the then Appellate Division, in this case, summarized the law on piercing the veil. And we know that the general rules are that one could pierce the veil in very limited circumstances, such as fraud, dishonesty, improper conduct. But in this case, in the Cape Pacific case, the court also said that there may be policy considerations that could provide grounds for looking behind a corporate structure and holding individuals liable. It's very difficult to see in this case why policy considerations do not justify looking behind a corporate construct of Precious Angels to hold Ms. Ngube liable. But in any event, it's our submission that this court does not have to go there. This court does not have to make a decision on this because it is, as I said when I began, it is the conduct of Ms. Ngube that is at issue. So this argument raised on her behalf, we would submit, is misplaced.
Continue.
Now, the other argument that's raised on her behalf is that the failure of the department to provide resources and to help her constituted an intervening factor that limited her liability. But this can't be true by the simple fact that despite all of those failures, which happened from the very outset, from the very time she started taking mental health care users, Ms. Ngube kept taking more mental health care users. Even after the first mental health care user had died in her facility, she continued to do so. So in those circumstances, she may not contend that she was placed in this situation unknowingly, that her conduct was not responsible for the deaths of the mental health care users concerned. And we submit that the evidence shows that she is prima facie liable for the deaths of 5 of the 10 mental health care users that we've dealt with. And I listed them at the outset. They were the ones who were at Precious Angels. So, my lady, with that, I'd like to move on from Ms. Ngube. I'm going to start now to look at the specific deceased. I'll start with each of the 5 deceased, first who died at Precious Angels, and then turn to the additional 5 who died elsewhere. The court will find detailed summaries of each death from paragraph 304 of our heads, which is at case lines page 54997. Before doing that, I want to just remind ourselves why this is important, because this next section of my argument may be a little tedious. And if it is tedious, it's because it is very fact-heavy. But this is the very purpose of this inquest. It's very easy for us to get lost in all of this evidence and expert evidence and pathology evidence. But at the end of the day, this is about individuals that died, and that's what I'd like to turn to now. The first deceased at Precious Angels that I'd like to deal with is Christopher Makgoba. We deal with Mr. Makgoba at page 55004. And the folder with evidence on Mr. Makgoba's death is volume 41 in case lines, page 7589. Okay, so Mr. Makgoba was born on the 6th of September 1970, and he died on the 3rd of July 2016. He was 45 years old. He was an epileptic. He was profoundly intellectually disabled. He was also wheelchair bound. He was transferred to Precious Angels on the 23rd of June 2016, and he died there 2 weeks later on the 3rd of July 2016. According to his prescription, he was on various very strong chronic medications. And we heard from Dr. Talatala that the combination of medications that he was on alone indicates that Mr. Makgoba required very complex medical care because his medications needed to be balanced. We know that he had been at Life Esidimeni Waverley for 7 years before being transferred to the Rand West facility on 31 May 2016, and then on to Precious Angels on 23 June 2016. And these transfers were despite the fact that when he was assessed by Dr. Wadwala on the day of his transfer, he recommended that actually Mr. Makgoba should not be discharged to an NGO because, I quote, he is frail, disabled, and vulnerable. He needs 24-hour care. And the reference to that is at page 7632. So despite this finding, Mr. Makgoba was transferred to the Danville property of Precious Angels with 21 other male mental health care users. Ms. Ngube, as we've heard, went to collect them at Randfontein and found them waiting already in the bus. Mr. Nofile took care of Mr. Makgoba. Mr. Nofile testified that Mr. Makgoba started to not eat well a few days after his arrival at Precious Angels, so very quickly after his arrival. Now, we bear in mind again that there was no assessment done when he was transferred to Precious Angels, and it's not clear that he was assessed by a professional nurse at any point, even when he got to Precious Angels. So Mr. Nofile tells us in his evidence that Mr. Makgoba stopped eating. When he refused to eat, he was fed with a syringe. And this was only after the food was made fine with Sister Julia's hands. It's not, Sister Julia wasn't shown to be a professional nurse, but it's what Mr. Nofile called the carer that took care of Mr. Makgoba with him. So Sister Julia made the food fine with her hands, put it into a syringe, and forced him to eat. Mr. Nofile explained that, quote, he was refusing to open his mouth, and we had to hold his hands and force his mouth open so that Sister Julia could feed him food with the syringe. Mr. Makgoba began losing significant amounts of weight. He exhibited aggressive behavior when his medication supply was low. And we know from Dr. Talatala's evidence that this is not surprising when patients are removed from certain medications. That's why they have to be taken care of in appropriate facilities. Professor Robertson's evidence was that no NGO could manage an aggressive mental health care user who was not given his medication. It was just not an appropriate facility for that. And you'll find that reference at page 54079. Mr. Nofile also testified that Ms. Ngube was informed about Mr. Makgoba's condition, but she failed to take him to the hospital for necessary treatment. In line with what Mr. Nofile said, the care worker that I referred to earlier, Sister Julia, that's Julia Mamchele, also said there was not enough food at the center, and the type of food available didn't allow a special diet for patients. There was no medical equipment like blood pressure machines, wheelchairs, or thermometers, she said. Another care worker, Nonhlanhla Eunice Ndlovu, corroborates that evidence and said that Precious Angels at the time didn't have any of these tools to monitor patients, that Mr. Makgoba's weight loss was significant, and she added that Mr. Makgoba's wheelchair was taken away from the NGO on the day that he arrived, so he was not mobile in any way. She states, that's Ms. Ndlovu states, that she made multiple calls to Ms. Ngube, expressing her concern that Mr. Makgoba needed medical attention and that he needed to be taken to a medical facility. But in response, Ms. Ngube allegedly stated, they are all adults and should figure out a plan. And reference to that statement at page 7694, which is the statement of Nonhlanhla Ndlovu. So when Mr. Makgoba's condition then deteriorated a few days after his arrival at Precious Angels, Ms. Ngube was informed several times that he needed medical attention, not just by Ms. Ndlovu, but also by Eugenia Beatrice Modipa. She mentions that in her affidavit as well. So we have a series of carers who are reaching out to Ms. Ndlovu and saying, Ms. Ngube, and saying, we need help with this patient. He needs medical help. He needs to go to a hospital. But we know he was never taken to the hospital, and it's not clear whether a doctor, in fact, even saw him. So what next happened was, as a consequence, was that on the evening of the 2nd of July, 2016, Ms. Ndlovu found Mr. Makgoba lying on the ground, and she took him back to bed. At 2 a.m. the following morning, she found him on the ground again, gasping for air, and she placed him on a sponge mattress. He was found cold and unresponsive in the early hours of the morning of 3 July 2016, and he was soon after pronounced dead. Christopher Makgoba was the first mental health care user to die at Precious Angels, and as I said, it took place only 2 weeks after his transfer. There were no medical assessments during his stay at Precious Angels. Dr. Talatala testified that Mr. Makgoba was a complicated mental health care user. He needed specialized care. In Dr. Talatala's affidavit, he highlights that Mr. Makgoba's diagnosis of mental retardation, epilepsy, and the combination of medications he was on made him a complex patient requiring specialized psychiatric care. He also noted in his expert report that the medications he was on required supervision by a doctor. Dr. Talatala said that the fact that Mr. Makgoba needed feeding meant that he had to be under some sort of supervision. Without supervised feeding, Mr. Makgoba would not be able to eat and he may die of hunger, said Dr. Talatala. He also said that his blood sugar levels would have been monitored because there's no other way to tell whether he's hungry, because it was unlikely that Mr. Makgoba would be able to communicate that he had not eaten enough. And for that, basic medical equipment would be needed. And we know from Ms. Ngube's cross-examination that Precious Angels did not have a blood sugar monitor. Now, in the case of Christopher Makgoba, there was no post-mortem done, but the pathologist, Dr. Rousseau, in his evidence concluded that the likely cause of death was linked to Mr. Makgoba's mental condition and questions whether his feeding was adequate since it was managed with a syringe. Dr. Talatala concluded that the care at the NGO was of below expected standard and that the NGO did not have the care that Mr. Makgoba needed. And indeed, Mr. Makgoba's periodical report indicated that he should never have been discharged in the first place. In his expert affidavit, Dr. Talatala states that the type of care required for Mr. Makgoba, in addition to specialized psychiatric care, is a team with experience in looking after individuals with intellectual disabilities, along with the patience and passion to do so. And he emphasized that any discharge to his family or to an NGO would have been risky, and if done, it would have to have been executed with extreme caution. We know that a hospital with basic facilities would not have been enough to accommodate these needs, as Dr. Talatala sets out. So therefore, an NGO would have been even more inadequate. And we see in the deterioration of his condition and the desperate pleas for him to get medical care that this, in fact, turned out to be correct. Ms. Ngube, in her cross-examination, conceded that Precious Angels could not offer Mr. Makgoba the level of care that he needed. And you'll find reference to that at page 48718. He was also left unattended for large chunks of the night, despite having been found twice in 12 hours before his death on the floor. In the second instance, he was gasping for breath. He still got no medical care. It is therefore unsurprising that the ultimate result was the death of Mr. Makgoba in these terrible conditions. And in fact, 2 weeks after Mr. Makgoba's death, the reports that I mentioned earlier on in my submissions that related that 2 weeks later, the department visited Precious Angels on the 20th and 28th of July. And there they basically found that Precious Angels was not adequate to take care of mental health care users, that it was too late for Mr. Makgoba. We submit that Ms. Mahlangu and Dr. Manamela created the circumstances in which Mr. Makgoba's death was inevitable. He should never have been taken to an NGO, but he was. And once he got there, it was a place that was simply unable to take care of him. Dr. Manamela should have been aware of that, and we submit she was. Ms. Mahlangu, in allowing this marathon project to continue, was responsible for this as well. Ms. Ngube failed to act to prevent his death. Had she taken him to hospital when she was requested to do so, had she obtained medical assistance when she was requested to do so, the outcome may well have been different. But she did not. And in our submission, there is therefore a prima facie case of culpable homicide to be made against each one of these actors. My lady, I'm about to move on to the next deceased, but I see that it's 3 minutes before 1. Can we take the lunch adjournment now so that I don't stop midway through one of the deceased?
I think that is in order. We'll take the lunch adjournment now and we'll resume at 2 o'clock. Thank you.
As it pleases the court.
May it please the court, my lady.
May it please the court, my lady.
Ms. Banglenda,
Thank you,
you
my
were just
lady.
about to start with another this.
Yes.
Yes, you may proceed.
Thank you, my lady. My lady, in view of the time, I'm going to do my absolute best to move quite quickly through the various deceases. As I say, there are still 9 more to get through. So I'll do my best. If we could then turn to the death of Miss Virginia Magapela.
I think were you not done with that? Oh, okay. You started with Christopher Makova. Continue.
Yes.
Yes.
So the first case lines reference to note in respect of Ms. Magapela is page 2593. That's where you'll find the evidence. The docket on her is docket number 7. Now we know from the evidence before the court that Ms. Magapela was born in January 1966 and she died August 2016 at the age of 50. She had dementia. She was wheelchair bound and she could not communicate verbally. She wasn't on any medication, unlike almost all of the other mental health care users that we've talked about. She simply needed care. She had dementia and she needed care. She had been at Life Esidimeni Rand West for 2 years before she was moved in a bus to Anchor House, and then she was transferred to Precious Angels. And this happened despite a periodical report which advised that she should not be discharged to an NGO because she was severely cognitively impaired. The report further noted that Ms. Magapela would continue to need assistance with her daily living activities. Now, Ms. Magapela died at Precious Angels within about 2 months of being there. And her sister was only informed 10 days after her death that she had died. Miss Ngumalo, her sister, managed to collect Miss Magapela's body on August 30th, 2016, and she transported it for an autopsy to Sefaku Makgato Health Services University. Now, while the immediate cause of death could not be ascertained at the autopsy, the postmortem findings did reveal severe malnutrition, dehydration, and gangrene on both legs. Dr. Talatala confirmed in his evidence that Ms. Magapela was emaciated. She had a weight of 35 kilograms. Dr. Noya testified that Ms. Magapela's death ought to be considered in the context of neglect. This was, he said, because there was food present in her esophagus, which appeared to have been pushed down her throat. In her state, she would have been, he said, too weak to chew. She would have required nasal feeding, and that we know is a feeding mechanism that was not available at Precious Angels. Dr. Noya also testified that while the immediate cause of death could not be determined, the prominent cause of death can only be linked to her dehydration and her emaciation. He elaborated by saying that gangrene, necrosis, and dehydration contributed to her death. And you'll find a reference for that at page 47419. Notably, Professor Tintinger, in his oral testimony, testified that the underlying cause of death is probably more important than the immediate cause of death. And that's certainly the case in respect of Ms. Magapela. From the date of arrival to her date of death, she was exposed to conditions of neglect. Her condition, that's dementia, would have meant that she needed to be reminded about basic things like meals. She wouldn't remember whether she had eaten or not. She would be reminded to stay hydrated. Her gangrene would have started with pain in her legs, Dr. Onoya said. And she would not have been able to express that she's feeling pain. And that's why the nursing care by a team who's familiar with her and her condition and familiar and trained in dealing with mental health care patients would have been able to spot the gangrene, for example, before it had got as far as it did. Dr. Talatala testified that if she'd had gangrene at Life Esidimeni, this would likely have been recorded on Life Esidimeni notes, which it was not, suggesting that it began at Precious Angels. The point is that, as Dr. Talatala says, if Ms. Magapela was properly cared for, and if she was monitored properly, she should have been taken to a hospital to check that gangrene so that a surgeon could amputate one or both legs, for example. The fact that she was not taken to hospital is indicative, we submit, of negligent care. Now, I want to move on then to the death of Terence Chaba. Terence Chaba was also a patient at Precious Angels. He is docket number 9. His death is dealt with in our heads at page 55012. He was born on the 9th of March, 1988, and he died on the 15th of August, 2016 at Pretoria West Hospital. Mr. Chaba was 28 when he died. Mr. Chaba was epileptic. He had cerebral palsy. He was intellectually disabled, and he was confined to a wheelchair. According to his prescription from Life Esidimeni, which was dated 21 June 2016, Mr. Chaba was on several very strong medications for his conditions. Dr. Talatala's evidence, which is described, which we get to in due course, was that this combination of medication alone indicates that Mr. Chaba required quite complex medical care. And we saw the same thing with Christopher Makgoba, that patients that suffer from these sorts of conditions have different, very strong chronic medications, and the engagement, interaction, and balance of those medications is critical, and that's why medical care, specialist medical care is required. Now, Mr. Chaba had been at Life Esidimeni Rand West for 2 years before he was moved to Precious Angels. In his case, there was again a periodical report recommending that he should also not be discharged to an NGO. And his periodical report stated that by necessity, self-care and feeding have been under strict supervision throughout his residence at Life Esidimeni. So whilst at Life Esidimeni, he was getting this very specialized care and fed in a way that, that took cognizance of his condition. So Mr. Chaba was at Precious Angels for 2 months before he was admitted to Pretoria West Hospital on the 8th of August, 2016. He had been found by a care worker on the 2nd of August. A care worker said he needed hospital care because he'd been experiencing decreased levels of consciousness. That was the 2nd of August, but he was only taken to hospital on the 8th of August. Ms. Ngube took Mr. Chaba to the hospital, but she failed to make his medical records available. So she delivered him to the hospital with no medical records. Dr. Talatala testified that the hospital was desperate for this information, and without it, it would have been unable to adequately manage this mental health care user. Because they didn't know what medication he was on. They didn't know what put him into this position of decreased consciousness. Mr. Chaba died a week later on the 15th of August, 2016. He died of bronchopneumonia. Dr. Tintinger said bronchopneumonia could also be a consequence of the severe malnutrition, emaciated state that Mr. Chaba was in. And it's important that, and this was notable, that Professor Tintinger noted that, and in his evidence he stood by this opinion, that a detailed investigation had to be conducted to evaluate the level of care that Mr. Chaba received at Precious Angels. So he too thought that neglect had a contributing factor here. In contrast to this, when he left Life Esidimeni, when Mr. Chaba left Life Esidimeni, from their records, he was described as sufficiently nourished and with no recent injuries identified. But 3 months later, just 3 months later, upon admission to Pretoria West Hospital, Mr. Chaba was described as unkempt, chronically ill, and with threatening bed sores on the right hip. And you'll find reference to that at page 2914 in case lines. So the inadequate care at Precious Angels we submit, contributed to his poor nutritional status, his susceptibility to bronchopneumonia, and ultimately his death. And it's not just our submission. This was the view of Dr. Tintinger. Mr. Chaba was the 13th person to die at Precious Angels. And notably, and this is an important statistic, he was one of 7 to die with pneumonia. So out of 20 people that died at Precious Angels, 7 of them died of pneumonia. If we then move on to the death of Daniel Josiah. Now, this is docket number 12, and it's dealt with in our heads of argument at page 55019. I'm trying to go fairly quickly through, but if I could just remind the court, I should have done at the beginning this afternoon, in our heads of argument, there is extensive detail on each of the patients, and I would just refer to the court to those aspects of the heads. So Daniel Josiah is at page 55019. He was born on the 8th of January, 1974, and he died on the 8th of August, 2016. His death was erroneously captured as the 8th of September, 2016 on the post-mortem, but he was 42 years old. Now, according to his medical records, he was epileptic, he had cerebral palsy, he was on medications for those, and he had a history of an old clavicle fracture. That's what the medical records referred to. He had been at Life Esidimeni Randfontein for about 17 years. So he was at Life Esidimeni for 17 years before he was moved to Precious Angels on the 23rd of June, 2016. And he died less than 2 months after being moved to Precious Angels. We would submit that that's not a coincidence. And it's a reflection of the standard of care that he obtained at Precious Angels. Mr. Josiah was dead on arrival when Ms. Ncube took him to Pretoria West Hospital. He died in her car on the way to the hospital. The post-mortem revealed that the cause of death was necrotizing pneumonia. The pathologist's schedule of observation noted that Mr. Josiah was severely underweight. And Dr. Talatala testified that for Mr. Josiah to have died of pneumonia before he was given any medical care was most likely because staff had not picked up an earlier respiratory infection. So the idea is that had they been trained and had they been exercising the appropriate level of care, the staff would have picked something up sooner. And Dr. Talatala attributed this to negligence or inexperience of the staff, because Mr. Josiah had cerebral palsy and an associated intellectual disability. So he wasn't able to tell them what was wrong. He wasn't able to tell them how he was feeling. So the obligation on the staff was to monitor him properly and to make sure that he received the appropriate level of care. He did not receive that care, and he died as I described. If we can then move to the next mental health care user at Precious Angels, and that is Matlakala Motsoahai. She's dealt with in our heads at page 55022. And Ms. Motsoahai was at docket 16. She was born on the 12th of September 1944, and she died on the 26th August 2016 at Kalafong Hospital. She was 72 years old. Now, the docket in this case doesn't contain any records from Life Esidimeni, but according to the Kalafong Hospital clinical records, Ms. Motsoahai had Alzheimer dementia, and she was bedridden. Ms. Ncube says she was not on any treatment, but the hospital records note in the background information that she was on Redac, which is a medication. And according to her daughter, Maud Motsoahai had previously been on that her mother had previously been on medication at Life Esidimeni. So that suggests that if Ms. Ncube said she was on no medications, that that Ms. Motsohai was actually not getting her medications at Precious Angels. So she was admitted to Kalafong Hospital in August 2016, and she was brought in by paramedics in a stretcher. A healthcare worker informed the nurses at Kalafong that Ms. Motsohai had a history of vomiting. It was observed that she had deep bed sores on the hip, that she presented with decreased levels of consciousness. She had a lower respiratory tract infection. She had a septic hand. She had renal impairment and something called hypernatremia, which is, I think in layman's term, something like too much sodium in the blood or equivalent to dehydration. Ms. Motsohai died 2 weeks after her admission to hospital on 26 August 2016. Dr. Talatala considered her case and testified that it was unlikely that she would have developed bed sores if she had been moved and was up and about, as he put it. And therefore, he said, it gives the impression that the NGO could not cope with this mental health care user's needs. She would have needed direct care and would have to have been turned every 2 hours, he said. And he concluded, quote, I would not place a mental health care user who is bedridden with Alzheimer's dementia in an NGO unless I wanted to hasten their death. And you'll find reference to that at page 44342, my lady. So we submit that Ms. Motsohai was inappropriately placed at Precious Angels, that resulted in her not receiving adequate monitoring, care. I dealt this, I was going to say this morning, but earlier this afternoon, with the conditions at Precious Angels. We know that those conditions were horrific. This mental health care user was placed there and died as a consequence. Those, my lady, are the 5 deaths at Precious Angels. What we see from those 5 deaths is a consistent pattern of neglect, of pneumonia, of emaciation or extreme thinness. And we would submit that it's not coincidence that so many people died at the same NGO with similar patterns of neglect. I want to now turn to the deaths at places other than Precious Angels. There are an additional 5 mental health care users that we refer to in our heads of argument. The first is Deborah Petla, and you'll find our section on Deborah Petla at page 55025 in our heads, which is our heads of argument. Ms. Petla was docket number 96. She was born on 25 May 1970, and she died on 26 March 2016 at Takalani Home. She was 46 years old. She died just 3 days after her transfer on the 23rd of March. She had been institutionalized for 38 years before she was moved to Takalani, and she died 3 days later. She was profoundly mentally retarded. She was an epileptic, and according to a 2013 periodical report that was provided to Takalani on transfer, she was totally dependent on staff for her basic needs and was known to eat rubbish. She was also unable to talk or to follow instructions. She was on a series of medications. She arrived at Takalani before the organization had been licensed. And as far as we are aware, there's no audit or inspection report in the record for Takalani. So we don't know what the conditions were at the time, but we do know that in 3 days after her being transferred there, Ms. Petla died. We do know certain other things about Takalani. For example, Dr. Selobano acknowledged in the arbitration that there was evidence included in a report about typhoid at Takalani in July 2016, and he described it as a facility that wasn't suitable. He mentioned that it had insufficient space, a pungent foul smell in the dining hall, and a very dirty kitchen. Dr. Robertson, not long after, raised concerns about problems with management. She referred in her evidence to workers being on strike since the 3rd of March and the impact of this very unhappy environment on mental health care users. Mr. Levi Mosenogi said that the facility was not geared up in terms of human resources and systems to ensure that these users received and recorded their daily medication and that they were medically monitored in respect of blood pressure, blood glucose, etc. Now, Ms. Petla died of asphyxia due to aspiration of blood at Takalani. A post-mortem was conducted on her body by Dr. Marule. He found foreign bodies, including plastic and brown paper, which he described as being a type of cardboard that would be used to make a cardboard box. He described the plastic as, quote, 2 bottled up plastics, which are the size of a fist. Dr. Marule also said that the upper part of the larynx was perforated and contused, and the lungs had a leopard skin appearance. And he was of the view that the perforation would have been caused by a hard object inside the larynx. Dr. Marule stated that, quote, the aspirated blood would most probably have come from the traumatized larynx, which most probably was caused by the swallowing of an object that was hard and sharp enough to cause perforation, and which was not seen during autopsy examination. And you'll find reference to this, if you bear with me, page 6599. So Dr. Marule thought it was most likely that Ms. Petla had swallowed this paper or cardboard at Takalani because it was still present in her body, and generally he said the speed of which paper or cardboard degrades in the stomach would have been fairly quick, so it couldn't have been there for much longer. So she couldn't have ingested it much longer before. So essentially this places the action that caused her death to have happened at Takalani. Dr. Marule also noted that death in a case such as this is a slow process and that Ms. Petla's death would have taken time. He described the process as akin to drowning, as the spaces in the lungs that should have been filled with air were filled with blood. And he suggested in his addendum to the post-mortem report that the autopsy findings are suggestive of management and care at the place where she was living not being adequate to care with her to take care of her incapacity. He also Dr. Talatala testified in respect of Dr. Petla that she was known to be at a risk of swallowing inedible objects. So any institution that took care of her would have to have known that and had to have made sure that there were, for example, no loose objects lying around. She would have needed quite close supervision. And Dr. Talatala's report was that nurses at Life Esidimeni would have known about this risk, would have managed it. And at Takalani, she was clearly looked after by staff who were not familiar with her and were not informed of the risks of taking care of her and how she should be taken care of. So the move, he said, Dr. Talatala said, from one facility to another put her at risk of swallowing objects, and her death resulted. And the staggering fact is that she survived for 38 years in institutions, but died within a few days of being moved to Takalani. I'll then move on to Franz Decker. This is dealt with at page 55033 of our heads. It's docket number 56. Mr. Decker had dementia. He was born in 1968 in September, and he died on the 7th of November 2016. So he had dementia, and he was on a wheelchair. He was wheelchair bound, I should say, because he'd had an earlier motor vehicle accident. He was also on a series of very strong medications. He had been at Life Esidimeni since 2003, and he was then transferred to Tsepong. He again was a case in which the periodical report recommended that he not be moved to an NGO. And this was because he had cognitive impairment, behavioral issues, and, quote, he needs supervision of treatment in a structured environment. And you'll find reference to that periodical report and the quote at page 4756. Mr. Decker had bed sores at Life Esidimeni, and he'd received treatment for them. In her evidence, Rochelle Gordon said that an NGO should not receive someone who is prone to bed sores. But he was in any event transferred to Tsepong. And on the day that Mr. Decker was transferred, that's 12 May 2016, Tsepong would end up receiving 93 people that day. It's a huge number of people. On the day that he was transferred, Karina Morales' evidence said she noticed he looked unwell and he had dots on his body. Okay, so that's in May 2016. But it was only in October that he was then taken to Kalafong Hospital for treatment of bed sores. In fact, on 9 May 2016, before he was moved to Tsepong, Mr. Decker was examined by a doctor, and there was no reference to bed sores at this time. So before he left Life Esidimeni, he had pre-existing bed sores that were treated. On the 9th of May, before he went to Tsepong, he was examined by a doctor, and there's no reference to bed sores. Dr. Talatala confirmed that if there had been bed sores, the doctor would have included that reference to bed sores in the space on the form allocated for skin. So Mr. Decker was transferred in May 2016. In June, the following month, he was presented at Kalafong with a swollen eye from falling. There is no mention in the hospital notes at that point of bed sores. Mr. Decker was at Tsepong for 5 months before he was taken to Kalafong Hospital for treatment of his bed sores. Okay, so they developed after his move. He was returned to Kalafong Hospital in October, and he was then admitted. The referral form from Tsepong states that he was dehydrated with sores all over his body, especially on both hips and buttocks, appearing as pressure sores. Ultimately, he died from septic, and I'm not going to be able to pronounce this properly, but it's septic decubitus ulcers, complicated by sepsis, and he died in November 2016. So between October and November, there were several hospital visits. Dr. Makoba, the pathologist, stated that his death should be considered to be unnatural. He also stated that there appeared to be prima facie grounds from which inferences of negligence can be drawn concerning the management of this mental health care user at the Tsepong Health Center. Professor Pina also concluded that there was negligence and incapacity on the part of the NGO involved. And you'll find reference to that at page 4804, my lady. If we then move on to the death of Charity Ratsotso, this is dealt with in our heads at page 55047. And it's docket number 73. Mr. Ratsotso was born in September 1968, and he died in July 2016 at Mamelodi Hospital. He was 48 years old. He was epileptic, he had severe mental retardation, and he was on several chronic medications for his conditions. Mr. Ratsotso had been institutionalized from early childhood, and he had been at Life Esidimeni Waverley since 2002, so he'd been there for about 14 years. He was transferred to CCRC from Life Esidimeni in May 2016. And in terms of CCRC's clinical notes, it was recorded that he had severe mental retardation or profound intellectual disability, and he was unable to care for himself. He was also a danger to others, and he was destructive to property. So he needed constant supervision. And the reference to that is at page 6202. After just over a month at CCRC, Mr. Ratsotso was then transferred to Anchor in June 2016. And this transfer of mental health care users happened to make space for other mental health care users who were being moved from Life Esidimeni to CCRC. And this all took place on Dr. Manamela's instructions. So the CCRC clinical notes report that he was transferred in a satisfactory condition and with discharge documents. Ms. Franks, my lady, you recall, disputed that she said she did not receive any information on his identity when he was transferred to Anchor. And although this is disputed, either way, it's clear from the evidence that at the point that Mr. Ratsotso got to Anchor House, his identity was not known at the Anchor House. So now what we have is a mental health care user with severe mental retardation, profound intellectual disability, who was unable to care for himself. He was a danger to himself and others. And now we have a situation in which he's been moved twice after being in one place for 14 years. There was evidence led about the effect of transfer on mental health care users, negative effects of transfer. So now we have someone who's moved twice in a short period of time. And the place that he ends up, Anchor, no one knows his name, no one knows his condition, no one knows how he has to be treated. We also know that there'd been no audits at Anchor or inspection of Anchor home at this time. So there were mental health care users transferred to this facility without any inspections or audits having been done. And in any event, what we do know is that when ultimately audits were done, it was long after Mr. Ratsotso died. Now, Professor Pienaar notes that Mr. Ratsotso's diagnosis and the medication that he was on meant that he needed total direct care 24 hours a day, 7 days a week, and under no circumstances could cope with indirect care. He explained this to mean that the person is compromised on several levels. They need care for every facet of life, and that this kind of care is impossible where you have a low staff to mental health care user ratio, as in the NGOs. He also notes that Mr. Ratsotso would have had difficulty swallowing, and this would have put a person at a greater risk of drooling and aspiration, and that itself required higher levels of supervision. So this is a situation in which this mental health care patient was clearly so vulnerable. He's unable to communicate, and no one knows what is required to take care of him. He was transferred to Mamelodi Hospital in June 2016 as an unknown mental health care user. And when he was transferred to the hospital, he was diagnosed as having continuous seizures. And he remained in Mamelodi Hospital until his death. Sorry, my lady. No, I thought you said something. He remained in Mamelodi Hospital until his death, which took place in the early hours of the 11th of July, 2016. Dr. Makgoba conducted a post-mortem on Mr. Ratsotso's body, and he found that the cause of death was in keeping with food aspiration complicated by necrotizing pneumonia. Mr. Ratsotso weighed 42 kilograms only when he died, and he appeared very underweight. So we submit in relation to Mr. Ratsotso that he should never have been transferred to a facility with a lower level of care, and that was CCRC, and then he should never have been further transferred to a facility with even less care that was known not to have an appropriate staff to mental health care user ratio, not to have the appropriate staff to that would take care of him. So he was put at serious risk. In addition to all of this exacerbated by the fact that he'd lost his identity. It's not clear at what point, but by the time he got to Anchor, no one knew who he was and how he should be medicated. So it's not surprising in those circumstances that he then experienced continuous seizures that resulted in him having to be in hospital. Then, my lady, if we can move on to Koketso Mohorani. Koketso Mohorani is dealt with in our heads at page 55057. He was born in December 1960, and he died on the 15th of June 2016, aged 55, at Rebafeni. He had schizophrenia, and the docket doesn't contain any of his records from Life Esidimeni. We do know that Mr. Mohorani had been institutionalized since the age of 26. So for about 30 years, he'd been institutionalized, and he'd been at Life Esidimeni most recently at Waverley since 2014. he died within 19 days of being moved to Rebafeni. Dr. Talatala clarified that while some people that have schizophrenia are able to live a normal life, if a person with schizophrenia is institutionalized, it would mean that they are on treatment, but the symptoms are not being sufficiently dealt with, so they need to be institutionalized. And he said that a person in this situation may have some psychotic features remaining, and they would be unable to look after themselves. They would require shelter, supervision with eating and drinking, the provision of medication, and ensuring safe behavior. Now, Rebafeni, where Mr. Moharani was moved, was an NGO that was on a small holding, so it was fairly remote. And at the time of his move until his death, there was no professional nurse at Rebafeni. A professional nurse only started mid-July when Rebafeni was paid by the department. Mr. Moharani's brother visited him at Rebafeni, and he said that he found when he visited him that he had already lost a lot of weight, and he was very distressed and he was very hungry. Dr. Talatala stated that the medication used to treat schizophrenia increases appetite, and if the NGO was not able to provide sufficient food, this would cause severe hunger and distress. He also noted that Mr. Moharani would have been familiar with his environment at Life Esidimeni, and so, as I mentioned earlier, a move or transfer of this mental health care user would have caused adjustment disorder, sadness, anxiety. Now, when the report from Rebafeni indicated that Mr. Moharani died after falling at night because there was no care in the upper level of Rebafeni at night, and his body was only found in the morning. While a person with schizophrenia doesn't need constant monitoring, Dr. Talatala told us, he does need to have periodical monitoring at night. And this would have happened routinely at Life Esidimeni. And Dr. Talatala's view was that this should have continued after transfer to an NGO. So Mr. Moharani is, again, another case where he had survived decades, 30 years in an institution, but died within 19 days of being transferred, completely unsupervised and in a place that he was unfamiliar with. He was hungry, he was distressed, and was, as was inevitable given his illness and his medication. Now, finally, I'd like to turn to Vuyo Aaron Gondwane. This is dealt with in our heads at page 55062. Mr. Gondwane is docket number 71. He was born on the 11th of October 1985, and he died on the 7th of February 2017 at the age of 31 at the Cullinan Care and Rehabilitation Center, CCRC. He was an epileptic, he had cerebral palsy, he was intellectually disabled, and he was confined to a wheelchair. Mr. Gondwane was also on chronic medication for all of these conditions. He had been institutionalized since he was 6 years old, and he had been at Life Esidimeni Randfontein since he was 24 years old. And then he was moved at the age of 30 to Anchor Home. That move took place on the 29th of June, 2016. When Mr. Gondwane was transferred, he was transferred in a satisfactory and well-nourished condition with 28 days of medication. You'll find reference to that in the patient progress notes, which are at page 6076. Dorothy Franks' evidence was that he could not eat, could not dress or wash himself, and he relied on staff for help. Similarly, when he went home for a leave of absence, on the forms that were filled out at CCRC, it noted that he needs help with personal care, needs help with feeding, with pressure point care, and that he must not be left alone. Now, ultimately, we know that he did not get the care that he needed at Anchor House. His mother, when she saw him, reported that he had lost a lot of weight and that his complexion changed while he was at Anchor House. He ultimately died from aspiration pneumonia, according to Dr. Stewart, who performed the post-mortem. Dr. Stewart found a large piece of orange plastic sheeting in his stomach, and she photographed it. It was around 50 to 60 centimeters by 20 centimeters. That's a very large piece of plastic sheeting. Dr. Stewart notes that there's nothing in the notes to indicate that the staff were aware that plastic, because it would have likely resulted in nausea, vomiting, abdominal pain, but nothing was noted on his notes. She also noted that swallowing something of this size would not have been easy, and it would have been a long, drawn-out process. So the implication is that if someone was monitoring him, they would have noticed this and prevented him from swallowing this plastic. When he died, Mr. Ngondwana was only 36 kilograms. Dr. Stewart characterized this as being very severely underweight and a sign of malnutrition. When his father identified his body, he had a sponge in his mouth that was full of blood. Dr. Talatala notes that the medications that Mr. Ngondwane was on was to treat convulsions, and that it was indicative of the fact that his epilepsy was quite difficult to manage, and that's why he was on those medications. And so a care facility should have been able to pick that up, and should have particularly been able to pick up that a patient had eaten something, because they should have picked up that something was wrong at an aspiration stage and not later when it turned into pneumonia.
You have gone past the time that you said to you yourself.
I'm almost done. I'm almost done.
Please just finish this.
I'm almost done. I'm finishing up.
Otherwise, you are eating into Ms. Foster's time now.
I understand, and I'll finish up. The important point to note with Mr. Ngondwane was that Dr. Talatale noticed that there was clozanapine in his blood. He was not prescribed that. And it's a medication that's used in patients with epilepsy. It lowers seizure threshold. So he was either given the incorrect medication or he was not supervised and he swallowed this medication. But either way, it points to a lack of neglect. So in conclusion, my lady, we've heard extensive evidence. We submit that it is clear, if one considers this evidence, that but for the conduct of Ms. Mahlangu and Dr. Manamela, these mental health care users would not have been subjected to mass transfer to places which were not able to take care of them, where they were neglected, they were tortured, they were starved, they were deprived of medication and proper care. And all of this took place as a result of the instructions and under the directions of Ms. Mahlangu, Dr. Manamela, and Ms. Ngube in relation to the patients of Precious Angels. My lady,
yes.
My lady, if you'll indulge me, South Africa has a long history of inquests and of findings, as George Bezos's famously titled book was, that no one is to blame. We implore this court to consider the evidence that has been led, to consider the conduct of Ms. Mahlangu as the MEC, Dr. Manamela, and Ms. Ngube, and to find that they're prima facie guilty of culpable homicide in relation to the deaths of the 10 mental health care users, and for Ms. Ngube in relation to the death of the 5 people under her care. Thank you, my lady. Thank you for indulging me with extra time.
Are you saying that the court should find them guilty of culpable homicide? I can't do that.
Okay. I'm saying that this court should find that there's a prima facie case that they need to face in criminal proceedings to follow. Thank you, my lady.
Thank you. Ms. Foster, are you there?
Good
yes.
Afternoon, yes, I'm present.
Afternoon, Ms. Foster. Are you ready to proceed?
Ready to proceed. Thank you, my lady.
Okay. You may proceed then.
Thank you. My lady, we have filed dates of argument, and I do not intend to read it into the record. We accept that the court is affair with the heads of argument and the arguments raised therein. So my argument will be succinct and focus on the nature of the proceedings. Now, as the court knows, the test is clear. It is tried that if criminal proceedings are not instituted in connection with death arising from unnatural causes, an inquest is held in order to determine the circumstances and the cause of death in question. An inquest is not a replacement or a substitute for criminal proceedings. It is aimed at making a determination whether or not the prosecution of any person for having brought about the death of the deceased is called for, and to consider and make an assessment of the available evidence for that purpose. We are dealing with a criminal prosecution. Prosecution is the domain of the National Prosecuting Authority. Now, in these proceedings, my learned friends, Mr. Leighton and Ms. Marriott, served as the evidence leaders, and that is all. There is no specific duty or role to play by the National Prosecuting Authority in an inquest, and the court could have appointed any evidence leader for that matter. Now, the NPA, the National Prosecuting Authority, has, in my submission, irrationally decided not to prosecute. My argument in this inquest relates to the unnatural deaths of the deceased Jaco Stolz and Jabulani Mhlongo. It will be docket 37 and docket 46 of the case lines. Now, the purpose which is served by an inquest was aptly described in the Appellate Division in Maree versus Tiley 1992, South African Law Report 899 in the Appellate Division on page...
Do I have that in your heads?
Yes, my lady, it is mentioned there, 901. On page 901, the underlying purpose of an inquest is to promote public confidence and satisfaction.
Okay,
to
continue.
That all deaths from unnatural causes will receive the proper attention and investigation, so that when necessary, appropriate measures can be taken to prevent similar occurrences, and so that persons responsible for such deaths may, as far as possible, be brought to justice. So
Yes.
what the considerations to be applied to identify or to qualify a cause as an element of liability may be the condictio sine qua non test, and that is logically the only test that the court can be applied in these circumstances to determine whether a negligent act or omission is a cause of the relevant result. There is no other test to be applied for this purpose. So the inquiry is very simple. Would the result have set in, but for the act of omission of the person concerned? In applying this test to a case, the court has to evaluate the successive acts or omissions that have preceded a given result. In this case, the death of Jabulani Mhlongo and Jaco Stolz. So the court has to determine these acts or omissions that constituted the cause contributory of the result. And the court only has to establish if a certain person was responsible for a certain delay which has contributed to the result. It will be irrelevant for purposes of testing the causation relating to any other person's act or omission. So each person must be evaluated individually. Therefore, the court must establish on the evidence of that specific person if he or she was responsible for a certain act or omission that contributed to the result. The causation relating to any other person's acts or omissions are irrelevant. So we have to pause and comment at this stage the role played by SADAF and Section 27. They must be commended as the real lawyer for the people. It is common cause that the result of their fears that has already been brought to the attention of the Department of Health on the 20th of October 2015 did indeed materialize. This series of events began when Ms. Barbara Creasy and Mr. David Makura testified that there had not been any discussion at the Premier Budget Council of any budget cuts for healthcare services, by implication, Life Esidimeni. Ms. Mhlongo and Dr. Silabano spread the word in issuing a letter to Life Esidimeni that the contract is terminated and that the number of patients have to be reduced by 200 a year as a result of the Premier Budget Council. So the only inference is that these two individuals deliberately misled Life Esidimeni as well as the Department of Health in general. It is ironic that the main reason for the decision was budget constraints. But my lady, my argument will be that no amount of money can be connected to a death of any person. This process was rushed and the patients had to be moved over a period of 6 weeks. We hear the argument about a causal link, but all these mental health care users were fine. They were in good health and they were doing well. Our clients were patients of CCRC for many years. Mr. Stolz was there for 18 years. Mr. Mhlongo was there for 8 years. When they were moved to the NGOs, they were starved, deprived of medication, dehydrated, abused. We hear of Section 27 of patients that ate plastic because of one single decision. Ms. Chambers testified that they tried to assist, but they were prevented to interact. We all know this saying that says, hear no evil, see no evil, speak no evil. Every single witness as a person that testified as a person of interest from the Department of Health wanted to abscond any liability and pass the proverbial buck. Ms. Cassandra Chambers of SADAG pleaded with the Gauteng Department of Health not to proceed with the project. Evidence and medical opinions were provided to them on their own cost. Now, firstly, I want to stand still with Dr. Selebano. Dr. Selebano was the HOD of the Gauteng Department of Health. He was a medical doctor by profession. Dr. Makachwa testified in his statement that on 14 November 2015 at Randfontein, Dr. Selebano promised the families of the mental health care users that they will be placed in similar or better facilities. Now, according to the dictionary, the word promise means a declaration of assurance that one will do something or that a particular thing will happen. Now, 54,000 pages later, we know that the only inference is that Dr. Selebano knew that the promise he made will have the reversed effect. Jaco Stolz and Jabulani Mhlongo were placed in worse facilities. Dr. Selebano, the appointed guardian of the mental health care users, did do something by sending these vulnerable mental health care users to inadequate NGOs. And the particular thing that will happen is that it led to the death of 144 mental health care users. The decision to terminate Life Esidimeni was taken by Dr. Selebano, and that can be found on page 1863 of the...
Is he the one who took the decision? Is that what you are saying?
And it's on page 1863. He signed 1863.
Are you saying the decision to terminate the contract was taken by him?
Yes.
Dr. Selebano?
Yes.
No. Isn't it he's the one who wrote the letter?
My lady.
We're talking about Dr. Selebano.
Yes.
Yes.
So,
are you saying he's the one who took the decision now?
He wrote the letter and he signed the document.
Yes, the letter, yes.
So Mr. David Makura under oath stated that he had no mandate to act on behalf of the Premier, that is Dr. Selebano, and that can be found on page 1865. So the event that set these tragic affairs in motion was done by Dr. Selebano. Dr. Selebano, as the HOD, terminated the contract. He gave long-winded explanations on why he did not actually have any knowledge of what was going on. But he was the center as the HOD of the Gauteng Department of Health and the appointed guardian of these mental health care users. All the email correspondence wherein the concerns were raised by SADAG, by Dr. Makachwa, the court application was addressed to him. Now I want to move on to Dr. Manamela.
Just before you move, I don't understand you. What are you saying regarding the issue of causation? You said something, I just got confused. If you can just take me back to that. You said something about, you said, I don't know whether, are you saying the court should disregard the issue of causation?
No, I'm not saying that.
I just didn't pick you up when you discussed that. If you can just maybe revisit that before you pass to other things.
I'm just going to repeat what I said. I said we hear the argument about a causal link.
Okay.
But all these mental health care users were fine. They were in good health and they were doing well.
Mm-hmm.
They were patients for CCRC for many years.
Yes.
18 years. Mr. Mhlongo was there for 8 years.
Yes.
They were moved to the NGO, that they were starved, deprived of medication, dehydrated, abused.
Mm.
And the evidence of Ms. Chambers was that SADAG tried to assist, but they were prevented to act.
Okay. Continue then.
Thank you, my lady. My lady, I then want to move to Dr. Manamela. She was a nurse indeed with a doctorate in psychiatric treatment. So for all intensive purposes, she can be regarded as an expert in the psychiatric treatment of mental health care users. We have also summarized her version, but it will be repetitive of what has already been placed on record by Advocate Hasim. All the problems that were experienced were conveyed to Dr. Manamela. The evidence was that she personally visited these NGOs, that she was the one who made the arrangements for medicine and food. Dr. Levete testified that there was instruction to close CCRC to make space for life in many patients, and that instruction was given by Dr. Manamela. Therefore, I'm going to, for the sake of time, I'm not going to repeat. The court has heard extensive argument by Advocate Hasim, so I'm not going to repeat it. The only thing that I want to add is that the decision to close CCRC or to move the patients from CCRC that was not life in many patients was made by Dr. Manamela. So Jaco Stols and Jabulani Mshlangu was innocent bystanders that were discarded and chucked out from their home, a home that they knew for 18 years and 8 years respectively, wherein absolutely no incidents was reported by any of those two families regarding those two deceased. With regard to Ms. Mashlangu, version was put on behalf of Ms. Mashlangu, and in short, her version was that the instruction for termination came from the Premier Budget Council. Now we know that both Mr. David Makura and Ms. Barbara Creasy denied that it has ever been discussed. Ms. Mashlangu also denied that she received any complaints from the Gauteng Department of Health. Dr. Manamela herself testified that she raised her concerns in all the meetings in the presence of Ms. Mashlangu. Then I want to move on to Hannah Jacobus. Hannah Jacobus did the scouting for the NGOs. She's the person who recruited them, she visited them, and she was the one who was in charge of the licensing procedure. She knew that Dr. Silabano and Dr. Manamela acted fraudulently and instructed her not to follow the policy. This can be found on page 28418 of the case lines on the record and page 28418.
38418.
No, sorry, my lady, I'm going to repeat. 284.
Yes. 28418.
Correct. And the other page is 28.
Yes.
431. Now, Siabadinga did not have a license, and CCRC had nothing to do with Siabadinga. But still, innocent mental health care users, Mr. Stols and Mr. Mashlangu, was transferred to an NGO that was so eloquently described by the Honourable Judge Moseneke as a death trap. Now, I also looked at the definition of a death trap, and it says in the dictionary, it's a structure or situation that is potentially very dangerous to life. The evidence on record is that there was no paperwork, no subsidies in place to pay the NGOs. Then the license of Siabadinga was withdrawn, and they had no place to put the patients. That can be found on page 28580. Hannah Jacobus admitted that there was not one single staff member of Siabadinga that was qualified to take care of a mental health care user. It is my submission that if there was one person who knew exactly what the state of affairs was, it was Hannah Jacobus. It was her job to ensure that the NGOs was properly licensed, resourced, and that patients did receive the proper medication. Judge Moseneke also stated on page 28705 that if you had done your job properly, would the people have died at Siabadinga?
Can I get that page number again?
287
Yes. 28705. Okay, continue.
My lady, then I want to move to Diane Noile, who was the CEO of CCRC. Now, she was in charge, and Siabadinga was on the same premises as CCRC. Ms. Noile testified that the condition of Mr. Stolz was good when he was transferred to Siabadinga. She knew that there was no qualified staff to take care of the mental health care patients. Sandra de Villiers, the sister of Mr. Stolz, testified that she called Ms. Noile and she informed her of Jaco's condition. Ms. Noile also testified that she received Jabulani Mhlongo with only 1 month's medication. She testified that his asthma spray and epileptic medicine was finished. She testified that she approached the clinic, but there was no budget for medication. So for the period 9 June 2016 to 25 June 2016, Mr. Mhlongo did not receive any medication for his epilepsy. She testified that he experienced uncontrollable fits. So she sent him to Mamelodi Hospital with a healthcare worker, where he died. Ms. Noile was in charge of CCRC. We heard the evidence of Dr. Lombard, who testified that he saw Jaco Stolz every single day, and he weighed around about 65 kilograms.
Just a second, Mr. Pitlele.
My lady, I apologize for interrupting. There is a factual error that she keeps referring.
We can't even hear you.
Apologies, my lady. Am I audible now?
Just continue, we'll tell you.
Okay, what I'm saying is, Dan Noile has no association with
Come again? She has no association with Siabadinga.
CCRC. I keep hearing her saying she's the CEO.
Yes, she said you. Miss
maybe if she can
Miss
clarify,
Foster, you are saying your submission, is it your submission that Ms. Noile was in charge of CCRC? Thank you, Mr. Pitlele.
What did I say, my lady?
You said Ms. Noile, I think you wanted to refer to Siabadinga because CCRC, it was Ms. Nyato.
I apologize. It is my fault. Thank you, Mr. Pislela. You are indeed correct. Person Nyato, I apologize. That's indeed so. So, Dr. Lombard testified that he saw him every
So you want to say she was in charge of Siabadinga?
Yes.
Continue.
My lady, sorry, I'm talking about CCRC. Is that what, are we on the same page?
No, we're not, because you were talking about all what you were saying about CCRC was that all these mental health care users stayed for a long period in CCRC before they were moved.
Yeah, that's correct.
Right? Yes, but then you spoke about Diane Noile. And I think you also mentioned that Ms. Yakubas admitted that there was not staff member at Siabadinga who could care for the users. So you were talking about Siabadinga. That's how I understood you.
But Ms. Noile was where?
Ms. Noile was at Siabadinga. Am I correct? I think I am. And CCRC, it was Mrs. Nyato. Am I correct, Mr. Pitlele?
That's correct, my lady.
Thank you. So you are talking about Siabadinga.
Yes.
We shouldn't confuse you.
No.
Your submission is that they were initially at CCRC,
Yes.
and they were moved in order to give way for patients that came from Life Esidimeni. Correct.
That's correct.
Mm.
All right. So Dr. Lombard saw Mr. Stolz when he was still at CCRC, and he testified that his weight was 65 kilograms. Now, when Mr. Stolz died, he weighed 36 kilograms, and in his opinion, the primary factor of this death was pneumonia, and the contributory factor was neglect. Now, Mr. Jabulani Mhlongo was again also for 8 years at the same place, at CCRC. And he did not receive his medication from the 9th of June up until the 26th of June. And this resulted in this chronic epileptic fits where he died at Mamelodi Hospital. Now, this Honourable Court is called to make findings as prescribed by Section 16.2 of the Inquest Act, Act 58 of 59, on the following: the identity of the deceased, the cause of death, and the date of death, and whether the death was brought about by any act or omission prima facie involving or amounting to an offence on the part of any person. Now, we submit that the following findings behove no argument: that the deceased, Jacques Stolz, died of the admission to sufficient care, and the deliberate negligence resulted in the cause of death to be ascribed to a natural death. Now, although the death was noted as natural, the deliberate neglect was the contributory factor. And then we also submit that the deceased, Jabulani Mhlongo, died of the admission to sufficient care and the negligence to provide him with his epilepsy medicine for the period of almost a month, and that the negligence resulted in the cause of death to be ascribed as a natural death. Although the death was noted also, the neglect was the contributory factor to his death. Now, why do we say it was deliberate? The court was taken step by step through all the warnings issued to the Gauteng Department of Health, but they still proceeded with this project. Therefore, we argue that the Gauteng Department of Health must have foresaw the possibility that these events might lead to the death of Jacques Stolz and Jabulani Mhlongo. We argue that the only possible
the department.
Yeah, indeed, so, my lady, because they were warned of what might happen. What they were warned about did indeed happen.
Yes, continue.
We argue that the only possible finding based on the evidence before the court in terms of Section 16.2D is that Ms. Mhlongo, Dr. Silabanu, Dr. Manamela, Hannah Jacobus, and Diane Oile's acts and omission brought about the death of the deceased Jacques Stolz and Jabulani Mhlongo, and that it amounts to offence. We have before now even stronger implored that the state prosecute them on 2 counts of murder. Acknowledging that this is not a trial, we will deliberately focus on assisting the court to make a just finding only in terms of Section 16.2.
How do you arrive at that, the murder, if I may?
Well, I will proceed. I'm nearly finished, and I will.
Yes, I want to. Okay, just conclude, and then maybe you need to explain so that I can capture your argument properly. Yes.
Mr. Stolz did not have food or medicine. It was not his decision not to eat or drink. It was simply not provided to him. He lost 30 kilograms up until his death. The implicated people must have foresaw the possibility that these vulnerable, voiceless people might die if not being provided with the necessary care. So it's dolus eventualis, and that is how we arrive at the conclusion of murder.
Okay.
It was simply neglect, because they were warned at the beginning, at the outset. They were provided with medical reports of what might happen if these mental health care users were moved to unknown facilities. They were warned, they knew what was coming, but they still proceeded. So they foresaw the possibility that this might happen. Mr. Mashongo also did not decide not to take his epilepsy medicine. It was simply not provided due to the fact that the NGOs did not receive the funding they were promised by the Department of Health. They did not have money to buy medication for these patients, and the patients were arrived at the NGOs with only 1 month's supply of medicine. So once again, the implicated people must have foreseen the possibility that a mentally retarded patient who suffered from severe epileptic fits, if he did not receive his medication, he could die, and that is murder.
So, you are therefore saying, mentioning the names of Ms. Mahlangu, Manamela, Selevano, Hannah Jacobus, and who?
Munoyile.
Oh, Diana Noyile. Okay, continue.
The circumstantial evidence is overwhelming in favor of a finding that the death was brought by an act prima facie amounting to this offence. Once again, this is not a trial, and no finding beyond reasonable doubt need to be made by this court. The test concerned is only a prima facie test. To this end, there is no acceptable version to answer the irresistible inference to be formed relying on this circumstantial evidence. My lady, and that will conclude my argument. May I just close with the following, as this will be my last chance to address the court on behalf of the four families.
Just a second before you continue. Ms. Ramaimela, you want to say something?
Indeed, so my lady, I just need my learned colleague to clarify something. At the beginning of her address, she mentioned that she has filed the heads, and we all agree the court has read the heads. And she merely said she is making submissions to speak to her heads. We just need clarity whether she still persists with what she said in her heads in respect of Mr. Mosenogi, because she has not addressed the court whether she
to him, yes.
Indeed so. So we just need that clarification as the court pleases.
Thank you. There you are, Ms. Foster.
As the court pleases, my lady, I'm not so sure to specific what aspect is my learned colleague referring to.
Ms. Ramaimelo.
I just need to find the paragraph.
Yes, I'm also looking. That's why.
Yes, that's what I minimized. I think it's paragraph 10.5. If I can just quickly look for my learned colleague's heads. There is mention of Mr. Mosenogi's name in the people that are being recommended for prosecution for the possible crime of murder.
I see that.
Is it 10.5?
Correct, you are correct.
Thank you so much, my lady. So I just want to make sure that when it's our turn to address the court, we don't have to assume that she did not mention him, and therefore the families are not proceeding with that submission.
Thank you so much,
my lady.
Miss Foster.
Thank you.
There you are, page 55342.
See that I did mention that. My lady, no, we are not proceeding with Mr. Mosenogi. I apologize.
Okay.
Yeah. My lady, can I
just a second? I just want to make a note. Yes. Continue.
Thank you, my lady. I just want to wrap up. Lastly,
okay.
My lady, so as this will be my last chance to address the court on behalf of all four of the families that we represent, we want to express our appreciation for the provided opportunity to promote the public confidence. Indeed, we have been assured that their deaths will receive the proper attention it deserves, and it was a privilege to appear before you again. So thank you very much.
Thank you, Ms. Foster. I see it is now 3:15. And in terms of what you have agreed upon the schedule, Ms. Foster was the one to close today. I don't know, because Mr. van Bergen, do you still stand by your request?
As your ladyship pleases.
But you come towards the end or after Mr. Profi?
As your ladyship pleases.
So that means Miss Maite, would you want to, let me see how much time you want. Miss Maite, are you there?
May it please you, my lady, I am indeed here.
Do you want to proceed now, or can we give you the opportunity to start tomorrow?
I would beg the indulgence of the court to start tomorrow, my lady.
Okay. Yes, Mr. Profi?
My lady, just for clarity, I'm sorry for interrupting. If we're going to everybody move up, I just wanted to ask if that changes the entire schedule, or how will we, am I still going on Monday, or do we all move up?
Yeah, remember there was this request, and you said, when I asked you, you said it doesn't make any difference, right? It is only in respect of Mr. Van Bergen. So, but if you're, yeah, if you, what are you implying that, because what is going to happen, it means tomorrow we can deal with Ms. Maite Shabangu, and Shabangu will wrap up, and then Ms. Mboweni. I don't know if Ms. Koka would want to continue tomorrow. If we can just deal with it now, but I don't see any problem. If she wants to stick to Monday, she can be afforded that opportunity, because we didn't anticipate that Mr. Van Bergen would want to be moved. Ms. Koka, let me not speak on your behalf.
My lady, I will be ready tomorrow.
You will be ready tomorrow, ne?
Yes, my lady.
Thank you. So in that case, tomorrow I think it will be until Ms. Boka. Yes, and the rest will.
I just wanted to confirm that I'm not in the running for tomorrow, that I will proceed on Monday then.
Okay, that's fine. Mr. Pihlela?
My lady, I was about to propose that.
You see, you have got a problem. Immediately we talk to you, we can't hear you, and I see you are so settled, eh? But you seem to be very far from. Yeah, perhaps we can come closer so that we can hear you.
I was about to venture a suggestion that we can start with this line for prosecution.
I don't think they hear you. I can't hear you. I just heard you that you wanted to propose something else.
Yeah, I was saying maybe it's something that
I can't hear. I hope I'm not the only one. Can we hear Mr. Pihlela?
No, we can't, my lady. I can't.
I can't, my lady.
I also can't, my lady.
Mr. Pihlela, perhaps you must just leave the meeting and rejoin. There's a problem.
Abandoning my suggestion.
Please check your devices before we start. Otherwise, if we're going to continue like this, we're going to encounter problems. Yes.
Yes, my lady. Apologies for that poor connection.
You are much better off. Yes.
Yeah, I was venturing a suggestion, my lady, that maybe we can finish with those whose clients were implicated at this stage, and then
come again.
Saying maybe we can then address what was raised in the heads by Section 27 and Ms. Foster as well, because those who are the ones who seem to motivate for prosecution, and then the others, because they are just going to address as a matter of course, then we can deal with them at the end.
I don't know. I thought you had agreed on this schedule, but then now if it has to change, I will have some problems. I don't know. Mr. Martin, thank you. Yes, Mr.